A very good morning to everybody present here. Before commencing with this program, we shall be observing a minute of silence in memory of Honorable Mr. Justice Mohan Shantanu Godar, who unfortunately passed away yesterday on the 24th of April, 2020. Okay. A very good morning to everybody. My name is Shayantan Bhattacharya. I'm a student in the 4th year at Symbiosis Law School, Pune, and I will be your compere for the day. I welcome everyone to the Symbiosis Law School Pune Conclave 2021. At this institution, we celebrate academia, discourse, and intellectual progress, and Conclave is our annual flagship event aimed at fostering the same. In the past, we have had the incredible pleasure of hosting legal stalwarts such as Honorable Justice Dinesh Maheshwari sir, Honorable Justice Abhilasha Kumari ma'am, and Honorable Justice Revati Mohite Dere ma'am, amongst many others. Continuing the high standards of this August event, this year we are honored to host an incredibly distinguished panel. Thematically, today's discussions shall be oriented towards global trade practices in the era of digitalization and recent developments pertaining to the same. A challenging event to organize, even in ordinary years, the circumstances that currently face us made the task particularly difficult this year. However, we remain grateful to our distinguished guests, the faculty at SLS Pune, and the student members of the organizing committee for coming together today to make this event a success. On that note, let us commence. Professor Dr. Shashikala Gurpur ma'am is the Dean of the Faculty of Law, Symbiosis International University, and the Director of Symbiosis Law School, Pune. Ma'am is a distinguished academician and orator, having presented more than 200 invited lectures, workshops, seminars across the world. She has an outstanding career with a wide range of experience in teaching, research, and industry. She has been a member of the Law Commission of India. Currently, she is a member of the Curriculum Development Committee of the Bar Council of India and the Academic Council. Ma'am is the advisory and PhD referee of several national law schools and universities across the nation. Recently, she was listed in the book 100 Legal Luminaries of India by LexisNexis, along with such stalwarts as Ms. Indira Jaisingh, Arun Jaitley, Advocate Ram Jethmalani, and several others. Ma'am was recently presented with the annual Kittur Rani Chennamma Award 2018 by the government of Karnataka for her work towards the empowerment of women. It is with honor that I request ma'am to kindly deliver the introductory remarks in the opening address.
Good morning, our esteemed chief guest, Justice Vishwanath Shetty, the Lokayukta of Karnataka, and also the former Judge, Karnataka High Court, respected Justice Menon sir from the Mumbai High Court, and who is going to be the guest of honor in today's first judges session, and Ms. Annabel Bennett, Dr. Annabel Bennett, who is the Chancellor of Bond University and who has been the former Justice in the Federal Court of Australia. A very warm, respectful welcome to each and every one of you. First of all, in these glum times, we are very honored that you have been there to bless us with your ideas, with your experience being shared to our youngsters Just a while ago, in the inaugural, I was telling that we were caught between the devil and the deep sea. The devil of the glum that we are surrounded with, the deep sea of how to keep hope high despite these times of despair. So one thing we thought was that it was our duty as teachers and as mentors to keep them inspiring, to give their young energies the opportunity to debate the issues and to what I call pledge for ending the human suffering. So epidemics is one, or pandemic is one such occasion which exposes our gaping wounds of social inequality, privileges, and others being unequally distributed. Now, global trade, on the one hand, can be kind of this gaping wound representing these huge gaps, especially in the light of sustainable development goals. But it is also an opportunity when the world is recovering from the devastating effect of this pandemic to speed up the growth of various economies. So in that opportunity, how those opportunities are going to be just and how those opportunities are going to be leveraged on the basis of digitalization or the digital era. Today, we have been giving this hope, or we are able to live the philosophy of this Simbo festival, the paradigms of progress, thanks to the technology. So this technology or this digital privilege, which is there in our hands, whether it is going to be a remedy or is it a panacea for all the problems that we have faced in terms of devastating economic effects, or is it going to be also another adding factor to the inequalities and injustice that bog down us as a humanity? So these are some of the core questions which are going to be debated in the light of the sub-themes of today's conclave later on. But as our tradition last year, which was started due to the initiative of our student Parantap, who will leave the portals of this institute soon, like our student advisory board president Sherville, who have brought together this idea of bringing great legal minds to debate with the students, to give their experiential nuggets, to understand such phenomena in the reality of our world, and how to gear themselves as future practitioners of law, future professionals of law, to be the torchbearers of justice in the light of these developments. So I was last year, I was moderating the session and we had judges separately addressing the issue, and then it was passed on to the practitioners because of certain protocols. As an introductory observation, I would like to say that we have very, let us say, enlightened three judges with us. Justice Vishwanath Shetty sir, with his vast experience as the Karnataka High Court judge and a very brilliant, successful law practitioner, has also been a man of charity, a leader, and true to his leadership, he has been appointed as the Lokayukta of Karnataka. The Lokayukta is a kind of anti-corruption wing of the government, which is even independent of the government and which has a telling power to bring back the government to its commitment to governance with the values of rule of law and justice. So I'm sure that with the situation that he is in, the location that he is in, which is the Silicon Valley of India, Bangalore, which has been the hub of digitalization, and which always calls far off people to come and invest in that favorable ecosystem. I'm sure, sir, you will have a lot of insights to provide in terms of how governance can poise itself to bring back the balance in the post-COVID period, and also where the balance has already been, let us say, readjusted in the work of the justice system. Perhaps there could be no other authentic voice than you or Justice Menon, sir, who is situated in the economic capital of the country, in Mumbai. And as the judge of the High Court, he also would have witnessed how the digitalization era has been the empowering mechanism, but at the same time, it has been a challenging mechanism in bringing world trade in conjunction with justice. I'm sure that Dr. Annabelle, with her leadership in education and former leadership in the justice system, would give us more insights located in the Asia Pacific leadership country in terms of how digitalization is a kind of ushering a force of equilibrium, but at the same time, a mute witness to the inequality. I was reading about how California was implementing a legislation on what they call as geek jobs or jobs in the technology arena. And the new legislation in the post-pandemic era is going to talk more about not hire and fire, not pink slips at the drop of a hat, but in terms of providing certain security, because the orphanization, the migration, and deprivation exposed, as I said, the existing inequalities. So a kind of collaboration at the global level between the principles of WTO and the commitments of ILO, which was a front runner to human rights movement in the world and justice in the world in the pre-United Nations era as well, how it could be reconciled at the global level and at the national level in terms of interpretation of the legislation where the justice system engages in, but inspiration that justice system gives to warn the governance to readjust the constitutional balance as the custodian of the constitution would be a very interesting insight that could come from this panel. I think as Kelsen himself identified the Grundnorm concept, the Grundnorm here is the constitutional value, the value of human rights, the value of rule of law, justice, how those could serve as the foundation in the wisdom of all three of you to build a basis for the next set of discussion that comes from the practitioners and academicians and scholars and organizations who have been in the forefront of this global trade, the practitioners who have been in the forefront of lobbying or representing the interest groups or advocating for the interests could be reflecting. So I'm sure that some of those might be in the audience, but the student audience who are here will definitely get these nuggets of wisdom and experience to learn in addition to what they learn in the classroom. We call it as learning beyond the classroom. So this conclave has those kinds of purposes. Aside from showcasing their talent, in the later on we will have a student conclave, but also law school as a repertoire of looking at producing multifarious legal talents, not just arguing the cases in the court or having a brief and representing the brief, but also in dictating the future of humankind. I'm sure that some of our students in this year, next year, and years on will get guided by this illumination that we are going to have through this conclave, which has hit upon the most important pain of our times, the global trade, which looks at a boon and a bane at the same time, with the 9% people controlling 90% of the wealth of the world. It's a huge challenge, and trade routes and trade processes guiding that. And it's only an independent justice worker who can think critically, evaluate, and that's what we want to produce, and we have been producing in Symbiosis. And mind you, all of you, sirs and ma'am, that this theme did not come from top down. It came from the students. That shows what kind of students we are training and nurturing. And also that shows what kind of confusion and anguish the youth of this country is harboring at this point. I'm sure that the global audiences who are witnessing this will definitely resonate with some of these concerns and issues. So with that introductory remark, I once again welcome each and every one of you, our keynote speaker, Dr. Annabelle, our guest of honor, Justice Menon, our chief guest, Justice P. Vishwanath Shetty. And I wish a great enlightening time to each and everyone, including ourselves. And we are also here as teachers to learn from you, the practitioners and the leaders, thought leaders. Over to you, Shant.
Thank you, ma'am. Symbiosis Law School Pune is extremely thankful to our dignitaries for taking out the time from their busy schedules to be a part of this event. This would not have been a reality without their presence. At the start of the first session, therefore, I wish to acquaint our audience briefly with the first three speakers for the day. Our chief guest is Honorable Mr. Justice P. Vishwanatha Shetty, who, as ma'am said, is currently the 8th Lokayukta of the state of Karnataka and a former judge of the High Court of Karnataka. Our guest of honor is the Honorable Mr. Justice Anil Kumar Menon, who presently serves as an additional judge on the original side at the High Court of Bombay. And our keynote speaker is Dr. Annabel Bennett, the Chancellor of Bond University, Australia, and a former judge of the Federal Court of Australia. I reiterate our gratitude towards having these individuals here. And with that, we will commence with the first session of the day. Honorable Mr. Justice P. Vishwanatha Shetty is currently the 8th Lokayukta of the state of Karnataka and a former judge of the High Court of Karnataka. Sir was elected and served as the chairman of the Bar Council of Karnataka from 1989 to 1991. He was designated as a senior advocate by the full court of the Honorable High Court of Karnataka in 1993. He was elevated as a permanent judge on 18th December 1995, where he served till his retirement on the 2nd of May 2006. Sir was also nominated as a founder president of the Karnataka Judicial Academy and has served as the executive chairman of the Karnataka Legal Services Authority. Sir has also functioned as a member of the National Legal Services Authority. It is an honor to have Sir amongst us today, and with this, I would request Sir to present his speech as chief guest.
Respected brother, Honorable Justice Anil Kumar Menon, Dr. Annabel Bennett, former federal judge of Australia, highly respected Dean of Faculty of Law, Symbiosis Law College, and the Director of Symbiosis Law Institution, Mr. Bhattacharya, Mr. Sharvil Adappa, and other office bearers of the Students' Union, members of the staff, young, good-looking, bright, sharp students of Symbiosis Law College. It is a matter of great privilege and honor for me to participate in this program this morning. Before I speak on the subject, I think it is appropriate that I should speak to the students the advantage of being a lawyer or a law student. This program of mine takes back me about 6.5 decades back, or 6 decades back, when I was also a student studying in the high school, college, and in the law college. The education imparted in a Taluka headquarters of then Udupi Taluk, which was a part of the then state of Madras, and the present Udupi district, had a arts and science college well known for its academic excellence, presently known as Mahatma Gandhi Memorial College, and also a law college. The building and infrastructure of the law college was not that what you have in your institution today in those days. But I must say, the academic staff, teaching staff of the law college was one of the best in those days. The commitment for teaching has helped many of us, including me, to achieve what we have been today. It is a best period. The student's period is the best period. It is the best period provided you utilize that period for your growth and development. I got into a law college because I could not get into a medical college. My marks did not permit me to get into a medical college. But I have no regrets for that. I repeat, I have no regrets. Those days, selection of joining a law college was the last choice. Today, That is not the position. Today, youngsters, young students, after the pre-university, their first option appears to be law college, study of law, because the opportunities provided are plenty. And getting into a good law college, like Symbiosis Law School, is a matter of great privilege for a student. Your initial advantage, the days when we were studying in a law college, the legal education was in a bad shape. It was a mostly part-time law colleges. Thereafter, 5 years law was introduced. National Law School was conceived as a modeling institution for the country, and now we have excellent law colleges like Symbiosis spread out all over the country. I would consider, with my experience as a lawyer, as a judge, and a man of the public, that legal profession is the best profession. You have opportunity to serve all cross sections of the society. We are governed by a democratic form of government. The opportunity in a democracy is immense. It is a child born in this country has an opportunity of occupying the highest position in the country. Maybe the President of India, Prime Minister, Chief Justice of India, everything. It is meant for the child. It is for the child how to proceed, how to occupy the position. What applies to a country applies to the world. We have heard a very learned, illuminating introductory remarks by your Dean, Dr. Shashikala Gurpur. She said, referring to a data, 9% of the wealth is enjoyed, the 9% of the people are enjoying the wealth of the world or the country. Now, if our country, if a democratic country provides an opportunity for every child born to grow and share the wealth of the country, I for one who believe every child in this country must be provided an opportunity to share the wealth of this country. The opportunity means to give an opportunity to grow, to provide good education, to put in place good health schemes, health sector. Opportunity should be given. It is the duty of the state, it is the duty of the parents, it is the duty of the educational institution. When a domestic state is required to provide a such opportunity, it is for the international committee, the countries all over the world to join and think how to provide an opportunity to all those people who are born in this earth. The one of the subjects which is slated for discussion today is global trade practices in the era of digitization. The world has become very small. By a click of the mouse, we can reach any part of the world. I can know what is the judgment of the High Court of Bombay or the Delhi or Allahabad sitting at Bangalore in few seconds of the pronouncement of the judgment. If I can access to the judgment, if I can access to the news cycle, everyone who is in the business, who is in the trade, can also access to the business activities throughout wherever it takes place throughout the world. The production activities are growing day by day. The needs of the consumers are growing day by day. Nobody is today satisfied with what is grown in his village, what is produced in his village or in his town, taluka, district, or the state or the country. Everybody wants to look into the best item, very quality item, the supply of goods all over the world. One thing everyone must, youngsters must remember is the foreign investment, the business from one country to another country progresses provided the legal system in this country is in good shape. If a investor, businessman from a foreign country intends to invest in India, he would like to know what is this legal system in this country, how effective it is, what is the tribunal provided for adjudication of the dispute, whether he is able to get his investment or not if there is a dispute. Therefore, it is a duty of all nations who are committed for good trade all over the world to provide a legal, the very highly satisfactory, honest, competent judicial system which would provide for speedy adjudication of the disputes. They can also provide for alternative mode of dispute resolution system. If there is if we can have ICJ for international dispute to resolve the dispute, for trade disputes also, we can have a similar tribunal institution created. On this, the leaders of various countries who are in charge of managing the country are to apply their mind, ponder over, and find out a solution. If you at one go cannot provide for one institution, one tribunal, you can think of providing for an institution for few countries where there is commonality between them, where they agree on certain institutions. What is important is the institution should be headed by very upright, honest persons, competent persons who who command respect all over the world for their legal acumen and judicial pronouncements. Digitalization has made the business trade easier and also difficult. The scope for misleading, misrepresentation in the matter of quality of goods supplied, in the matter of services rendered, in several aspects that can be a scope for dispute. One of the parties may commit a breach. We know if a contract takes place within the within a country, we are governed by law of contract, we are governed by law of sale of goods act, partnership act, various other domestic laws. And we can easily fix the jurisdiction of the tribunal or the court. We can easily make out who has committed a breach, when the order is placed, whether it has resulted in a contract, it has resulted in a final completed contract or agreement, or whether there is withdrawal of an offer. All the several aspects regarding transactions can be easily found out, decided if the dispute is within the state country jurisdiction. But if the transaction takes place on internet by way of digitalization, where the breach takes place, where the offer is accepted, whether there was oneness of the mind with regard to the quality of the goods, the quality of the services to be rendered, there may be a scope for wider dispute. Therefore, fixing the jurisdiction in the case of dispute is a very difficult task. This has to be decided. On this, international law must be developed, how to do it, possibly what applies to a law to a country, with modifications that is applicable to different countries, also made applicable to the international law governing trade practices. One other thing is, when you go and see in your eyes, you are satisfied with the quality of the good. You go to the same shop, you go to the same supplier. Same is the principle, because of the confidence you have in that shop, in that gentleman who offers the goods to you, who offers the service to you, it may be a doctor also. Therefore, medicine through telemedicine. Therefore, when there are various, if it is to be on digitalization, international trade has to take place. What is important is the supplier of goods, the person who gives services, must ensure, must build up confidence with regard to goods he supplies, the quality of the goods, the commitment he has made to the purchaser or the consumer, and also the quality of service. Then only international trade with the facility of digitalization, when there is a lot of advantage to improve and develop the business, develop the trade, but if there is a breach of confidence, if there is a mistrust developed between one country and other country, with regard to the nature of business, the citizens of that country are carrying on with another country, the quality of the goods they supply, the quality of the service they render, then possibly, eventually it may give hope for failure of international trade, global trade, the trade in the digital era. Therefore, when there is a wide, huge scope for development of trade, international trade, on account of the present trade practices, every country and its businessmen and all people who have got commitment to develop this international trade practices must be committed for the values in business, for values in life, not to betray the confidence other person to the business. Now, only I think my time is over, only 1 minute I will take. My duty as a Lokayuta is twofold. One is to redress the grievance of the public and to bring about transparency in state administration to prevent maladministration. The students of the present generation have a very, very important role to play in prevent maladministration in the state administration. Corruption is one area of maladministration. When we speak of maladministration, we only talk of maladministration or corruption only in the public offices, only in government offices. And we tell you from my experience, this maladministration, corruption is no way lesser in volume than that is in the government offices. Therefore, what is important is, if you want to have a good international global trade, international trade, your trade practices also must be free from corruption. One country big businessman should not bribe your purchaser. You may purchase several things, maybe medicine, maybe defense products, various things for your country, or you may supply these things to your other countries. But if the corruption gets into these transactions, whole system will collapse. Therefore, my appeal to younger students who have a bright future is to prevent corruption taking place in any form. It must start from your house. You can advise, you can make a request, touch the feet of your loved ones, maybe parents, maybe uncles, your close ones, your friends' parents, to get rid of the corruption in the society. Then only a country, especially a developing country like ours, can develop, and we must become a part of growth of the world. Therefore, please, you have a youngsters have a very good opportunity. You have many routes before you. Which route, which road you take, it is for you. You want to have a short circuit, you want to go through a strenuous journey and achieve a permanent success. Once you succeed in the profession, the success is permanent. Just a honest trade is required. We require honest, efficient, competent bar. They will give good advice to the society. It will bring down litigation. They will be the ultimate distributor of justice. It is from the bar we get the district judiciary and the judges from the constitutional courts. That strengthening the bar is very important. Therefore, improving the legal education is very important. And effective steps to improve the competency of the judicial system is important, not only from the distributing, dispersing justice to your citizens, also to pave way for development of international or global trade. I thank the Dean, students of the Symbiosis, union leaders of the Symbiosis Law Students Union, and the students and everyone associated with this program for giving me this opportunity to share few of my thoughts with you. I thought we'll have sufficient time to speak about on online media tribunal and global data privacy, which was initially thought of by the institution. These are also two important contemporary subjects. Now, our discussion should not be a class, uh, classroom discussion. Everything, if the student wants, everything is available in the library, internet. Please try to improve your quality of performance. As a student, what you learn, what registers in your mind, it is permanent. At my age, if you read something, you will forget in few days. What I have learned as a student, even today, what with whom I have come across, I remember. Therefore, please acquire as much knowledge as possible. Life is a competitive one. More the knowledge you have, you are better than others. Therefore, you must be competent. You must have more knowledge than others. You see, the advantage of this, you will know when you start practicing, course will respect you, your reverend counsel will respect you. If you are highly knowledgeable, learned, and truthful to the court and try to uphold justice. Please don't be under the impression somehow you have to get relief to your clients. No, you have to get relief to your clients in accordance with law, in accordance with justice. Therefore, please remember, you have a duty to the court, you have a duty to your opponent, you have a duty also to the opponent client without compromising on values, committing professional misconduct. Again, I thank for giving me this opportunity. I wish all the students a bright future. Thank you very much.
I thank Honorable Mr. Justice Shetty for their enlightening comments. And with that, we proceed to the guest of honor's address. Honorable Mr. Justice Anil Kumar Meninsa presently serves as an additional judge on the original side at the High Court of Bombay. Sir holds a bachelor's degree in philosophy and an LLB from the University of Mumbai. Appointed as a judge on the 3rd of March 2014, Sir has adjudicated over a swathe of civil and commercial matters, arbitration matters, and matters pertaining to the media, construction, engineering, and many other streams. Over the course of Sir's career at the bar, he has held numerous positions of distinction. He has been a member of the Bar Council of Maharashtra and Goa, functioned as counsel for numerous reputable houses, such as the Kerala State Electronics Development Corporation, the Children's Film Society under the Ministry of Information and Broadcasting, and Hindustan Copper Limited. His practice spawned appearances at the Company Law Board, the erstwhile MRTP Commission, the Delhi High Court, the Bombay High Court, amongst others. This demonstrates clearly the breadth of Sir's expertise, and with that, I would humbly request Sir to deliver his speech today as the guest of honor.
Thank you, Mr. Bhattacharya, for the introduction. First of all, two corrections. I have never been a member of the Bar Council of Maharashtra and Goa, number one. Maybe the data compiled sourced from erroneous records. So I've never been a member of the Bar Council. So correction number one. So good morning to all our esteemed participants, our distinguished panelists. Justice Shetty, thank you for your enlightening address. It's a bit of advice which is welcome from a senior person like you. And I'm sure the students have greatly benefited from your suggestion that they must join the bar, because nowadays what we find is that young lawyers are keen on avoiding bar practice. They'd rather go in for non-litigative work, which is something that it's good. I've been a non-litigating lawyer also, but I think the experience at the bar is something that you will never gain by sitting behind your desk and in front of a Zoom conference such as this. So get into the bar and then choose your future. That's what I would really suggest. The thing is, let me give you a bit of advice to start with, is that when I was a raw junior, when I started my practice, a senior member of the bar pulled me aside on my first day and said, look, young man, there is the law is in the law books. And the judgments are being delivered by the courts every day. You can always read it up, but learn the practice, learn the procedures, so the other side may not fool you. So that's one of the principal, main bit of advice that I got, and I found it so useful, because unless you know the procedures, you can get fooled by a smarter opponent, right? So students must bear that in mind. And it's not all hunky-dory doing your law in a good college. You have so many opportunities as Symbiosis. I've had relatives and friends' children also pass through Symbiosis, including colleagues. So use your time here well. And with these few words, I'd rather learn today from all of you, because as a practitioner, sorry, correction number 2 is additional judge is for 2 years. And I've completed almost 8. So you're no longer additional judge for those of you who are unaware of the structure of the constitutional courts. 2 years is when you're first appointed, and then once you're made a permanent judge, you don't seem continue as an additional judge. So that's another thing you must remember. As Dr. Shetty, or as Justice Shetty was saying, the experience that you gain at the bar will really hold you in good stead as a practitioner. But today's topics are so interesting that when I was requested to participate, I said, let's give it a shot. I'm no expert. I don't claim to be an expert in the WTO tariffs or the GATS, but I have a little bit of exposure off and on. So I'd rather have you people share today, and after hearing Ms. Bennett, I'm sure we'll have an enlightening discussion. I'd rather interject. I'd rather participate in the discussions. So shall we just get on with that, since it's already 12:15 IST? Is that fine, Dr. Gurpur?
It should be fine, sir. It should.
I think so. So I think let's get into it, because there's a lot to discuss. You see, as I've seen your theme, it's about blockchain. It's so interesting, and you have the Supreme Court struck down the government order on Bitcoin. Now there's a law going to be enacted. I don't know what the position is. Maybe our students are better, they're more knowledgeable on this aspect. So how do you avoid blockchain? What can you do? How do you secure privacy, data violations, etc.? Everybody is now peeking into your Facebook accounts and your WhatsApp. WhatsApp, of course, they claim encryption, but we really do not know. So I think the students are probably at an advantage in the new technology bit. So I'd rather wait till we hear Ms. Bennett, and then we go on with our discussion. Thank you so much.
Okay. I thank Honorable Mr. Justice Anil Kumar Menon. Sir, I apologize for the shortfalls. We had a bit of an issue with the data collection. It is our fault entirely. Yes. Yeah. Right. With that, we proceed to our third speaker, our keynote speaker for the day. Dr. Annabel Bennett is the Chancellor of Bond University, Australia, and has served as a former judge of the Federal Court of Australia. Ma'am holds a PhD from the University of Sydney and an LLB from the University of New South Wales. Ma'am's career covers her services in a range of illustrious and important offices. She serves as the chair of the Australian Nuclear Science and Technology Organization Board, as well as chair of Guardia, a leading infrastructure investment firm. She is an arbitrator at the Court of Arbitration for Sport, the president of the Anti-Discrimination Board of New South Wales, the director of the Garvan Institute of Medical Research, and the chair of the WIPO Advisory Group of Judges. Additionally, Dr. Bennett is a member of various institutions, such as the Australian Academy of Science, the Australian Academy of Law, as well as many others. Ma'am has served on panels such as the panel of arbitrators of the HKIAC for IP disputes, as well as the ICSID panel of arbitrators. Noting this is merely an indicative list and certainly not exhaustive, I would reiterate our honor and pleasure at having ma'am amongst us today. And without further ado, I would now request ma'am to take over and deliver her speech as the keynote speaker for the day.
Thank you. I must say, first, I would like to give my respects to all the distinguished panelists and speakers and indeed the students, and to tell you what an honor it is for me to be here with you today. I have to tell you a little bit about how this came about, because it lends itself also to some of the theme that I wish to discuss, and that is international judicial comity. Because many years ago...
Hello.
Sorry, is there a problem? No.
I am so sorry, ma'am.
Okay. Many years ago, can you hear me? Is it okay? Okay. I got involved in an exchange. I led a delegation of judges to India from the Federal Court, and I was fortunate to have a number of trips to India. The only bad news is, of course, that I didn't get to come to Pune today, which I would have much preferred to being here and speaking to you by video conference. But then I met a wonderful young judge called Chirag Banhu Singh, and we have kept up contact through all of this time, and it's his son Parentap who got in touch with me and asked me to participate today. And of course, even though it's Sunday, I couldn't say no, because I have such a wonderful relationship with his father, and through him now I'm very appreciative of being invited to speak here today. But I've also had the wonderful, I should reiterate, by the way, I would encourage all the students to go to the bar. That was certainly my experience, and it's given rise to a career that, as you've heard, it's given me a multitude of opportunities. I should say that I have sat on both the Bombay and Delhi High Courts when I've been in India, which was an experience that was absolutely fantastic, and I enjoyed that immeasurably. And I've maintained contact with a number of judges. Many of them have become more senior and have gone on to become Chief Justices at various states, which has been a wonderful experience for me to follow their careers. And also, of course, some of the judges of the Supreme Court of India who have been extraordinary people that I've had the good fortune of meeting. Apart from that, though, I've been asked to get involved in a number of things, both during my bar career and my judicial career, and then again in my post-judicial career. And I'm going to share with you a couple of those because they are relevant to the topic today. First, without going into details, I've actually sat on a World Trade Organization arbitration where the topic was very much linked to digitalization because it involved streaming services and alleged breaches of contractual rights to stream sporting events and matters such as that in different parts of the world. I won't go into that. Those who are interested can always read it on the WTO site. The one area that I thought I would talk about, though, is something that came up. It's not directly related to trade, but it's part and parcel of every aspect of the digital world. And that is this. I was asked by the New South Wales Attorney General to head up a Law Reform Commission inquiry into digital assets on death or incapacity. And it sounds very boring, and I thought it would be boring, but I have a daughter who is actually a professor of law, and her specialty is the intersection of law and technology. So like a good parent, I thought that if I did this, maybe I'd learn more about what she does and would give us another bond between us that we could have a conversation. And in the meantime, I came to understand much more. So let me give you an example. I taught with her actually a joint course with the University of Zurich. And as part of that, we went with the University of New South Wales and we went to Google. And there were all these people who were very involved in technology. The students were all students who were specializing in technology. And because of this Law Reform Commission, I asked them how many of them had done anything about what would happen to their digital life if something happened to them. And not one of those students had done anything. And indeed, most of the staff at Google had not done anything. So there's a real issue that we face, that we all have a digital presence. Now, some of that, and we changed the definition, some of that is properly called digital assets. My Instagram account is not an asset. Kim Kardashian's, if you know who she is, or a famous film star, their Instagram account is an asset. They can sell it for a lot of money. But we all have digital records. So we've changed the philosophy of not just looking at assets, but at records. So we looked at what do we do? Because what happens, and people don't understand this, first, most people, when they die or become incapacitated, and it's not always predictable, have done nothing about who can access their digital records afterwards. Now, almost every platform has its own service agreement. And many of those service agreements provide that you cannot share your password, and that when something happens to you, if your account is inactive for a while, it will be terminated. And yet it may be very important, not only for the people looking after your affairs afterwards, but also for your family to want to access some of that information. And at the moment, they in most countries of the world, they can't do so. And the service agreements won't let you do so. So your Microsoft, your Google, your LinkedIn, your Twitter, they each have a different arrangement of what you can and can't do. And most of you, I'm sure, look, don't get me wrong, I'm sure as fabulous law students, when something comes up with a 25-page set of conditions that you have to agree to before you can access something, you may read each and every clause. But most people, like me, just go straight to the end where it says agree, click on agree, because you have to anyway to get access, and then you're in the space. But you don't realize that, for example, your Facebook page might become just in memoriam and nobody can access it. Nobody can access your cloud with all your photos on it, and nobody can access your affairs. So this was a real problem, because at the same time, you have privacy concerns. And I know you're dealing a lot with privacy today. So you've got privacy concerns that also have to be taken into account. You also have, and certainly in my country, a principle that you must give due deference to the wishes of the testator. And a disabled person may not be totally disabled, but may not be able to deal with the internet. And their wishes also have to be taken into account. So how do you balance all of these matters in a world where nobody has made arrangements for it? Sure, people can go to the courts and seek to have some sort of interference with that, or get orders from the court to allow that to happen. But there are two issues that come out of that. The first is it can take a lot of time to get that access. Secondly, it can be very, very expensive. And thirdly, courts can take different views. I'll give you an example. There was a case in Germany where the parents of a girl who had taken her life, unfortunately, wanted to have access to her Facebook page. The first instance court said no. The intermediate appellate court said no. And the ultimate court of appeal said yes. So judges can take different views, and they had to go through all of that process to get that access. In New York, there was a situation where somebody wanted to get access to photos, and again had to go through a legal hierarchy until they got that access, because there are service agreements. And don't forget that some of those agreements will say that the law to be applied is the law of Ireland or something like that. And so you've got that complexity, and also there are privacy concerns. So all I can do is to tell you that these are the sorts of problems that are part of the digital world. And as a former barrister and a former judge, I was asked to head up a team to look into this. And we made a recommendation about a statutory provision that would allow people in a hierarchy to have someone have access to the material without having to go to court. And ultimately you could go to court if there was no relevant person, but it allowed for, I won't bore you with the detail, but we brought that in because to get over the fact that access is often denied to people who need to have access to that. And one of the ways we dealt with privacy was to say that there would be statutory provision that any such person had to act as a fiduciary, and also that they could not disclose any information that they gain, that they can have they can get access to the person's digital place. They could deal up to a point, but only as necessary to give effect to their duties, much as a normal administrator would do. But it would create a criminal offence of giving out information about the person or any third person to anyone else as part of the process of having that access. So that's important, not only at a personal level, as you would understand, but also at an international trade level, because one of the things people have on their email accounts, for example, they might have invoices, they would have contracts, matters such as that would not necessarily be accessible even to their employer. So it is important that everybody who is working in the digital environment then turns around and makes sure that they make provision by way of a digital administrator or some methodology. If there's not a statute in place, and I don't think many countries of the world have one, I think the United States has got one and Canada's got one. We looked at theirs and didn't think they were, quite frankly, good enough for our purposes. So we've now got one, or we're going to bring one in. But I thought I would raise that as an opportunity for you to think about how you can use your legal skills broadly in problems that arise because of the digital environment that may not be obvious at first. They may not be directly in trade, but at the same time, they can be unbelievably relevant. Then I'm going to come to another area that I consider very important in the IP space, in the digital space, that is not, again, directly in the topic of trade itself, but it has an enormous impact on trade. And of course, we're seeing it now with the pandemic, and very much in your country and in other countries where the pharmaceutical companies' rights are being questioned by those with regard to traditional IP rights. And that's to talk about various aspects of intellectual property. Now, to talk about that, I have to explain something else, which brings me back a little bit to the topic about how my interaction with the judges in India has been such a wonderful experience in my life. It's not only the judges in India. The world, I've had the opportunity to deal with judges from all over the world. And the one thing, and I'm sure the other distinguished judges on the panel would agree with me, that problems are coming up to the courts and judges are having to deal with them, and they're new problems. They've got no precedents, and problems are being encountered concurrently all over the world. And some judges are very experienced in the underlying questions, like those of intellectual property. Some judges have not had experience with IP before they became judges and have had to deal with some of these issues, as they would say, on the run. So there are a number of areas that we have to look at as to how that can happen. Justice Shetty raised questions of, in effect, unfair competition. What do you do when it's all over the internet? Where's the jurisdiction? Who has the right to deal with breaches of copyright, breaches of trademark, inappropriate advertisements? Where do they originate? Who's the one who's got the jurisdiction to deal with it? When you make an order in the court, how do you make an order that will have an impact beyond your own borders? And judges are having to deal with this, and it comes up in a number of different ways. So you've got it in every aspect. So you've got questions of copyright and questions of computer code, and there are copyright issues there. There are copyright issues, of course, on the internet all the time, alleged breaches of copyright. And the other area that I want to speak a little bit about is patent law, because digitalization invariably means that you're dealing with new systems. And so judges, again, have had to deal, and lawyers have had to argue them, to deal with what has been, in effect, the computerization of business systems. Now, you have a real problem there, because classically, patents are there to spur innovation. And it's meant to be a deal or a contract between the inventor and the community, where the inventor will give that invention to the community in return for a 20-year monopoly. And that classically, of course, has been the deal and the arrangement. But now you have a situation of if everything is patented, will that stultify, will that prevent development of further matters? And that's contrary to the interests of society. At the same time, you want to encourage inventors, and inventors, I mean, people own, you have property and people accept you're entitled to protect your physical property. So why can't you protect your intellectual property? So look at the computerization of business systems. One of the first cases that came up was somebody who brought about a wonderful computerized share index. Now, that had all the things you would want out of something that should be able to be patented in the interest of commercialization. Certainly it made it much faster. Everything on the computer is much faster. It was much more efficient. It was a terrific business system. Could it be patented? Now, possibly in classic patent law, you would allow that to happen. But the courts basically have said we are not prepared to close off all computerized business systems, because of course, once it's patented, you've got questions of how other people can work with that and not infringe. So are you giving a monopoly that is not warranted? And so judges all over the world have had to come to grips with it. They've explained it in different ways. But in the end, it's come down very much to the idea that if you don't actually make the computer work better in some way or other, if it's just a system that utilizes a computer, then perhaps that's not a patent. Or as the Europeans would say, if your invention doesn't itself have a technical effect. Now, you will have to argue these cases. Judges have to deal with these cases. This is like looking at how many angels can dance on the head of a pin, because the analysis of what has it, where is the technical effect, can very much be based upon how the patent is written or how the case is presented to the judge, what the lawyer says is the invention, in order for someone to have to analyze it. And there are questions here of policy as well as of law. And I know in the introduction, Dr. Gilbert addressed questions, broad policy questions that you will have to deal with in your lives. And I think that as these go forward, the policy questions are not only in questions of human rights and broad issues about the rights and wrongs of society, but also in what otherwise would be seen as narrow areas of law, like patent law. You have to make decisions on balancing the rights of the innovator, the rights of the inventor, the rights of society to work in invention, the stimulation of innovation. And yet, in this current world, if you allow everything to be patented, trade might stop because people won't know. People have to know, as lawyers, you'll be asked to give advice. What can I do within this system freely to me? And where do I have to take a license? So some of those issues are issues that you are going to have to deal with. You are going to have to help the development of the law in these areas, both in the areas of contract, in the areas of property, and in the new areas that digitalization will bring about. Because how does the law develop and how do these problems arise? Brilliant young students think up brilliant arguments for their clients to try and win the case. And then they go to the judges, and the judges have to listen to the arguments and try and weigh them up. And of course, your country and mine both has an adversary system. So we have to listen to the arguments and make decisions based upon those arguments, which is really incredibly hard. So what does it come down to? It comes down to keeping your mind broad on these areas. If you get a chance to work in an unfamiliar area, say yes, because you never know when you will need that skill set in a case that you will have to be in advice you have to give, and in a matter you will have to decide when you yourselves become judges. So as an example, it was mentioned that I have a PhD. My PhD is in cell biology. And when I first became a lawyer, it was a bit like Justice Shetty. I wanted to do medicine originally, like you, and I decided not to do it because I decided that it would take me too long. So I spent 14 years at university doing a PhD, a postdoc, and then law. And for the first 10 years at the bar, I didn't use my science at all. But then I started getting a case. Someone heard I had a science degree and gave me a patent case. And gradually, all of that skill set, I started being able to use those things that I'd learned years before and bring it to play in my practice as a lawyer. So whatever it is you get an opportunity to work in it, because you will never know later where that knowledge and the people that you meet in that circumstance will not help you to solve a particular problem that you have. So that's how I got into intellectual property, and that's how I then became involved in all of these issues that cover both the precise questions of law and the broader questions of policy. That is how I got involved with questions of digital access. And these are just problems that are happening as we speak. So you're going to have more of them. Now, like the previous speaker, I don't want to take up too much time. I've probably spoken for too long already. I cannot tell you how thrilled I am to be part of this conclave, how I thank Parent Hap for reaching out to me, and to the director and to the law school itself, I must say, for taking a chance on inviting me, because if there is one thing that is happening what has happened in the past have been the relationships between the courts of our countries, certainly the cricket teams of our countries. And I should say, by the way, I sat on, one of the other matters I did in my sporting world, I did sit on a case for the International Cricket Council, and that was a case between India and Pakistan. And if any of you were interested, in fact, that case was decided in favour of India, and that's a matter of history, not a matter of disclosure. But today, in the world of trade in particular, your country and mine are getting ever closer. So it's important for the lawyers in both countries to be aware of the laws as they are developing in your country and in mine, because in that way, the global trade will be much more beneficial, because you need to know how cases are going to be decided with the partner country with which you deal. And in a case where it's all being done remotely, so much is being done remotely by Zooms, but also by using all of the availability of digitalization, you need to know the developments in my country, and we need to know the developments in yours. So with that, I will say thank you very much. And I will stay for a little while, but then unfortunately I did have a prior commitment and I will have to go before I hear the totality. But I know it is going to be a very, very exciting conclave, because the topics that you've got here cover, each one of them would take a 3-hour discussion to work through. So I hope you come up with novel and ingenious ways of solving the problems.
Mr. Bhattacharya, if I may just interject. Dr. Bennett, before you leave us, there are 2 questions that I have for you, if you could enlighten us. Is it true that internet service providers in Australia keep logs and pass it on to the government, number 1? Is it true as a fact? Because there are reports that that's a practice. And second, what about your run-in with Google? How far have you got? I mean, are you still using Google, or you have found alternate resources?
You mean in terms of the government's view, the latter question first?
Yes, yes. On facts, of course, yes, yes.
Taking on Google as it comes. We're still using Google. We still are very much using Google. I think there are still negotiations taking place between the platform providers and the government on it. It is a very interesting topic, and in a number of ways, Australia is taking on a lot of these things for everybody. But yes, we are using Google, and I haven't heard any recent developments, which means in the newspapers, which means that it is happening quietly. But I gather it did come to a head, and a lot of very hard things were said. But I think now it's easing off, and I think they're going to come to an arrangement. There were various threats made about closing Australia down, but there was pushback on that, and it hasn't happened. As to the internet, I'm not aware that the internet service providers, we have are providing information to the government. If they are, I mean, for example, we have some things where, because of COVID, we have to sign into every venue to which we go. And yes, that information is available to the government, but only for a period of time, where it is then wiped completely. And that's only to enable contact tracing. So we do have strong privacy laws and privacy considerations. So if the government wants access, it would have to go to the courts to get, I would have thought normally, in a specific case for a specific reason, to try and get access to specific data, because we have all sorts of laws concerning recordings and telephone intercept and all that sort of matter. So I don't think that's happening.
All right, thank you so much.
Indeed. I thank Dr. Bennett for her enlightening and wonderful speech. I think I speak for all of us when we say that the first session was extremely enlightening for all of us. With that, we will now have a brief deliberation and question-answer session, I believe, with our distinguished guests. And I would request Professor Dr. Gurpur ma'am to kindly moderate that session.
So we are proceeding from the judges' deliberations to the prolonged discussion on the themes. Welcome all our dear esteemed speakers, the lead senior advocates from the Supreme Court, our international speaker, Professor Tachik. So I would request to proceed once the introductions are done. Would we be able to do the introduction first, Shayantan, as per the table program, introducing the personalities, and then I would start formal question answer.
Director, may I take your leave now?
Oh,
with your permission.
Yes, sir. Yes, sir.
Thank you. Thank you so much. Thank you. Thank you.
Okay, so do we directly proceed to question answer?
Absolutely, ma'am. So we will be in session of.
Sorry. Sorry, we have power there.
Am I audible?
Gauri ma'am reporting already. Gauri Gokhale ma'am, has she come? Who all? Arun has come. Gauri has come. So yeah, Advocate Tripathi is also here. So we'll begin with the discussion. Now, when do we introduce the personalities to the audience? It is when they speak, because this is a panel discussion. Therefore, it may be that it will move in a kind of, yeah. Therefore, I request that we introduce the first two advocates. Yeah. Yeah. So quickly do the introduction.
Yes, ma'am. I will be proceeding with.
Yeah.
Absolutely. So we can start with the second session then, I believe. Okay. I welcome everyone to the afternoon session.
Thank you.
I'm so sorry. I believe that was a problem at my end. I welcome everyone to the afternoon session of the Symbiosis Law School Pune Conclave 2021. At the offset, I would thank our distinguished guests for this afternoon for coming with us and for gracing us with their presence today for this particular discussion. Without further ado, I shall proceed to introducing our audience to our guests for this afternoon. Firstly, we have with us Senior Advocate Mr. Mukul.
Is there some interruption?
I think so, ma'am. I think there is.
Yeah. So I think Shayantan has got some difficulty in connecting. He's trying to introduce. So till he comes back, dear audience and also the respected panelists, these kinds of hitches are always there with the technology. I'm very happy to introduce the first speakers in the panel, Advocate Mukul Roth, the Senior Advocate of Supreme Court of India and also former Attorney General of India. Welcome, sir. Thank you for agreeing to enrich our students to debate on this most crucial topic, which is related to the age of digitization and the global trade. Shayantan, can you continue? Yeah.
Yes, ma'am. I'm so sorry. I'm having a bit of an issue with my net. I proceed. I welcome everyone to the afternoon session of the Symbiosis Law School Pune Conclave. At the offset, I would thank our guests for joining us today. It is unthinkable what we could have achieved without them today. And with that, without further ado, I will proceed with their introductions to acquaint our audience with the distinguished individuals that we have amongst us today. Firstly, we have with us Senior Advocate Mr. Mukul Rothgi, sir. Sir is currently designated as a Senior Advocate in the Supreme Court of India, reading for his LLB at the Government College in Mumbai. Sir commenced his career by joining the chambers of notable practitioner, Mr. Y.K. Sabharwal. Sir went on to serve as the 14th Attorney General of India from 2014 to 2017. In 2005, Sir had been appointed as an officer of the Order of Australia for his service to the law and the community. He was also the recipient of the Law Day Award in 2008, which by then Prime Minister of India, Dr. Manmohan Singh. Sir has represented the Indian government in a range of landmark cases including the Triple Talaq case, the Aadhaar privacy case, and the NJAC case. It is an honor to have Sir amongst us today. Next, we are joined by Senior Advocate Mr. Parag Tripathi, sir. Sir is currently designated as a Senior Advocate at the Supreme Court of India. Prior to this, he had served as an additional Solicitor General of India. Having completed his LLB from the Campus Law Center at the University of Delhi, Sir went on to read for the LLM at the Harvard Law School on the prestigious INLAC scholarship. Sir has argued several landmark matters before the Supreme Court, such as arguments pertaining to the Mandal Commission, the Shaw-Wallace corporate dispute, the 2G spectrum case, the Commonwealth case, and the Harshad Mehta case. Sir is a notable arbitration practitioner as well, with the first arbitration at the Singapore International Arbitration Center having witnessed arguments from him. Sir holds the position of an honorary adjunct professor of law at the Jindal Global Law School. It is an honor to have Sir amongst us. Next, we are joined by Advocate Pavan Duggal, sir. Sir specializes in the fields of cyber law and e-commerce law. He is a member of the NOMCOM Committee on the Multilingual Internet Names Consortium. Sir serves as the chairman of the International Commission on Cyber Security Law. Sir has several books to his credit and notably has authored India's first mobile law treatise. Sir has also functioned as a member of various committees, including the Permanent Monitoring Panel on Information Security of the World Federation of Scientists and the Membership Advisory Committee of the Internet Corporation for Assigned Names and Numbers. We are honored to have Sir amongst us today. Next, we are joined by Dr. Przemysław Tachi, who is an assistant professor at the Institute of European Studies at Jagiellonian University in Krakow. Sir holds a PhD in philosophy and one in law. He serves as a visiting lecturer at several leading universities like the SUNY at Buffalo, the Universität Salzburg, the Max Planck Institut für Ausländisches Öffentliches Recht und Völkerrecht, Universität Heidelberg, and many others. Sir has authored 3 books and over 30 articles in English and Polish. It is an honor to have Sir amongst us today. Next, we are honored to have amongst us Ms. Gauri Goklema. A practicing lawyer for 25 years, ma'am leads the IP, technology, media and entertainment, and data protection law practice of the research and strategy-driven international law firm Nishad Desai Associates. She has assisted several international businesses in India-related strategy, regulatory advice, corporate and strategic deals, and litigation pertaining to TMT and pharma. She has spearheaded several policy initiatives for the TMT and pharma industry, including for online content companies, the gaming industry, as well as privacy and data protection laws. She has been named in several legal directories, including the Hall of Fame for Technology, Media, and Telecommunications in the Legal 500. We are honored to have ma'am amongst us today. Moving on, we are joined by Mr. Arun Prabhu, who is a partner in the General Corporate and TMT Group at Cyril Amarchand Mangaldas. Sir advises clients in matters pertaining to electronics, IT-enabled services, outsourcing, and information technology sectors. He was a member of the working group of the Government of India on the legal enablement of information and communication technology systems. He has advised companies like Google, Samsung, Flipkart, and Truecaller on crucial technology matters. He was awarded the Notable Practitioner distinction by IFLR 1000 in 2020 and 2021, and was also awarded the Up-and-Coming distinction for TMT by Chambers and Partners in 2020. We are honored to have Sir amongst us today. Finally, we are joined by Mr. Supratim Chakraborty, who is a partner in the Corporate and Commercial Practice Group at Khaitan & Co. Sir is an alumnus of our law school, Symbiosis Law School, Pune. He has been recognized as a notable practitioner in the IFLR 1000 rankings in 2020, and has also been recognized as a leading individual in 2021 in the Legal 500 edition for data protection in India. Sir is a member of ASSOCHAM's National Committee for FinTech, Digital Assets, and Blockchain Technology. And he has also spearheaded various important stakeholder consultation meetings
organized by industry associations on the draft Personal Data Protection Bill. As we can all understand, this is an exceptional and distinguished panel. And I know that I speak for all of us when I say that we are waiting to hear the panel deliberate on today's theme. With that, I request Professor Dr. Gurpur ma'am to now take over as we commence the panel discussion.
Thank you, Shanthan, and good afternoon, the esteemed panel. It's a pleasure to invite you all to this rich discussion. This is such a beautiful galaxy of eminent practitioners, and we also still have our senior judge, Justice Vishwanath Shetty, listening to us, I think, behind the scene. We have the panel, which is international in some sense, Indians with international exposure and experience, and international personality like Tachik, who has been a full round kind of lawyer, judge, and now the academic, aside from his commitment to research in philosophy and law. Our senior advocates and our senior experts like Advocate Pawan Duggal have enriched this galaxy with their experience as well as their engagement with the multiple dimensions that we would like to unveil in this conclave. Some of the dimensions that we are going to unveil are, as the panelists have been informed, and as the students must be aware and the listeners must be aware, is first of all about transaction data leaks, because we are talking about global trade as a huge possibility and a practice in this era of digitalization. The era of digitalization became more pronounced with the pandemic because there was increased pressure to have this as the only access, the digital route, because the physical routes were becoming difficult. By then already the power of the digital technology was unveiling huge possibilities in concentration of global trade as well, and in efficiency of global trade as well. And here global trade did not limit itself only to goods, although the equipment and the media occupy the highest levels of transactional material in global trade. We have services trade as becoming the new in thing. And also, as you know, that technology has that power to concentrate and aggregate the services from any part of the world, in any part of the world. So we are seeing that both the developed and the developing countries getting affected simultaneously, and some of the crucial issues like transaction data leaks in this global trade is very important for all the players in the global trade. The other ethical and legal issue of the regulation of big technology, the big tech giants, and the way it is affecting the consumers as well as the monopoly and the smaller players in the big tech area is another issue that we have taken up. Aside from that, its impact on cross-border merger and acquisition and merger is an issue. We are looking at the power in terms of business, market, and democracy being affected by the big tech, by these players, and how it is changing the scenario of cross-border merger and acquisition. We are looking at the possibility of a uniform law for global data protection. Just now, Justice Annabelle was also highlighting about that, the online theft, the online identity, and multiple issues involved there. Can we have a single law, or can we have a uniform law? I mean, this was a debate which we witnessed even when global trade law was emerging. Should we have one law, or should we have harmonizing of the laws with that global standard? So what we call in international law, fragmentation or integration. We have a Harvard graduate here in the form of Advocate Tripathi. I'm sure that he would have read these things or participated with the people like Thomas Frank who are arguing about it. The other is online dispute resolution. Already the Supreme Court coming to grips with the e-court. Yesterday I was debating about that. Is it e-justice or e-court? So e-court dimensions, and internationally or globally, how online dispute resolution mechanism is good, or what are the challenges which are there, especially with the data privacy, because they're saying even e-justice has that inherent risk. So how do we deal with that? How have you dealt with that in your practice or in your understanding? And the last one we are looking at is the new future of international banking, global trade, and finance. And now that's one very interesting area for our youngsters with their engagement with cryptocurrency, understanding of what we call as blockchain technology and its connection to the currency, and whether the current traditional system of banking is going to be hampered, and how the state is resisting it, but the consumer is not resisting. The consumer cannot resist the temptation of getting rich or participating in it. It gives that power of access and participation, whereas larger issues of justice remain unaddressed. There's a very close conjunct between this and the way we have managed now the Netflix or Amazon. The consumer wants it, but the regulator is unhappy. People like us, ethicists, are unhappy. Lawyers are unhappy. Academics are unhappy, because somewhere the rights landscape is being treaded on in a very free manner without any consideration to whose foot you are stamping on. So these are the kinds of reality we are in. And in here, there are certain very important developments, which I will specifically question to the specific experts. But before that, we would like to listen to two senior advocates from the Supreme Court. First of all, I will request Advocate Mukul Rohtgi, the senior advocate of Supreme Court and the former Solicitor General, to kindly come in line and enlighten the audience on some of these issues that we have raised from your background, sir.
Good afternoon to all the panelists and all the organizers. And it's a delight to see that these new and futuristic aspects are being debated. Let me first confess that I am not very savvy with all the topics that you have chosen, but I will try to give my point of view in as brief capsule as I can. So first of all, let us talk about online dispute resolution. Now, online dispute resolution would encompass courts in their traditional sense, because they resolve disputes, and I would extend it to say arbitrations. Now, in the last 1 year or so, we have seen a shift from physical courts, physical arbitrations, to virtual courts and virtual arbitrations. I have seen in India, various high courts and the Supreme Court are using different apps. The Supreme Court uses an app called Video or Video Connect. The Delhi High Court uses WebEx. Bangalore uses Jisti. Some other high courts use something else. Now, the Supreme Court got its app specially designed, maybe for more protection, because Zoom and WebEx are kind of open apps where people can join. Now, we have had teething troubles in dealing with these apps, because sometimes connectivity is low, sometimes you are muted, sometimes there is disturbance, etc., etc. But we have not really had a case where confidentiality is kind of breached. And that is probably because when you do cases in a court, by law, they are meant to be public courts. Everybody can understand and follow what is going on in a court. There is talk that courts should become online, like Parliament. And if that be so, it will be streamed. So in a regular case, which you are conducting, a civil case or a criminal case, there are no real confidentiality issues in that sense. But there could be cases, more so in arbitrations, where you have some kind of confidential data which is shared between parties. In courts, it is very, very rare to share confidential data. It's only in interest of states or morality or those kind of interests that there is an issue of confidentiality. But whatever be the nature of the issue, it is necessary to coordinate and work in conjunction with that online dispute resolution provider. So in other words, the High Court or the Supreme Court must work with the app with which they are functioning, say in order to maintain that nobody records the proceedings without the authority of the court. Suppose you are doing a sensitive matrimonial case. You don't want it to be recorded and streamed online because it affects individuals and their private lives. So there you will have to have a system in conjunction with the app that firstly, the record of proceedings, if any maintained, is destroyed, and no recording is made which may be sent. Now, but more important than that, the real issue today is protection of data. Now, I have seen, and some of our panelists also, Mr. Tripathi and Mr. Dugal, we are doing cases on a regular basis on behalf of WhatsApp, Facebook, or against them, that these platforms are using data and in one sense breaching privacy also, which is today a fundamental right. By using data, I mean that it is obvious that if you are using, say, Google to search regularly, say, for buying a motor car, and if I constantly search for cars which are luxury worth 40, 50 lakhs, the platform will pick up the kind of profile I have and then start sending me advertisements which are related to that bracket. Same way for a smaller bracket. And they use data. If I order something on Amazon, or big data as it is called, where they analyze huge data. You have local data protection laws in some countries, and in our country, the bill is pending. There is a huge outcry. And let me tell you, there is a case pending in the Supreme Court where somebody says that yes, WhatsApp has an encryption from end to end. So if I send a message on WhatsApp to a friend of mine, neither WhatsApp will read it, nor can it be shared with somebody. But WhatsApp certainly knows that I have spoken to a friend 10 times in a day. And by the location of my phone, they know where I am and where that other person is. So that is also kind of a breach of privacy, that I called somebody 5 times and you know that. So should anybody know that I called somebody 5 times, whether I spoke for 1 minute each or half an hour each? That is also an issue which is now being examined within the purview of privacy by the Supreme Court based on that Puttu Swami case. Now, you have data leaks. We had that Cambridge Analytica scandal, etc. Now, what happens? You have hackers. You are doing transactions. I mean, every day I find messages that people have lost money from their bank accounts because some kind of innocent message comes to an unwary person that you are going to get, let's say, 1 lakh of rupees if you do something, and you give a PIN or you give an Aadhaar number or do something, and that is hacked and taken away. So that kind of thing is happening across the world. And because of a world of no barriers, somebody in America will take away money from your credit card, somebody in India will take away money from a credit card abroad. So we need to have very, very strong methods so that these online transactions have safety. Every time that I have been to Thailand and we come back for after a holiday, we get a message from our bank that even though there is nothing untoward in a particular transaction, but the fact that you have used your credit card, say in 3 hotels, makes it suspect because they have the security number at the back, the 3-digit number. And therefore, you, Mr. Rodgi, better take a new credit card. That is also an indication that these kind of breaches, which are criminal in nature, are happening. Now look at tech giants like Facebook, Google, Amazon. They reach across the world. They have information about millions of people. The kind of food you eat, the kind of dress you wear, the kind of comforts you have, the kind of likes and dislikes you have. And they have all the information. Take another way. The moment you use your credit card, which is given in India, but you use it in a country abroad, the same moment when you use it, say in a hotel in New York, the card provider based in India immediately knows that at 11 a.m. in the morning, you were in such and such hotel in America where you have swiped $100. So the problem is that when we move towards a digital world and we are willing to do everything, you have dematerialized shares now. You don't have physical shares. So you need an electronic locker to store your electronic shares. Frauds can happen even there, even in such situations. The point which I'm trying to say is, the more and more we move towards a digital era, the more and more controls, restrictions, parameters, and safety is required, because you are not dealing face to face with a person so that you can actually go and keep something in a locker. Now you can't do that. Maybe an international media tribunal may be required to deal with such huge conglomerates across the world. What kind of information is being transferred or being breached? There is in fact a petition pending in the Supreme Court of India in that behalf, but that is local in nature. So maybe you will need some international conventions which go beyond local data protection laws. You have some law like a Commonwealth law or a WHO law or a UN kind of a convention, like you have convention under the Arbitration Act, Geneva Convention, this, that, and the other. So those kind of conventions in which you have compartmentalized regulations, either for online transactions or for mergers or for online dispute resolution between India and England. Say, take a case of an arbitration governed by ICC Paris. ICC Paris governs it. One party is Indian and one party is African. Now, this kind of thing is going on. God knows where this data is going, how it is being breached. So ICC Paris will have to have a tie-up or a collaboration, let us say with an app called WebEx, to ensure that safety and security and privacy is maintained while conducting this kind of an arbitration. Maybe artificial intelligence can help in detecting frauds, money launderings. It can help in doing mundane work. It is being tried to be used by the outgoing Chief Justice of the Supreme Court in trying to find out patterns, bunch cases of similar nature, etc., so as to deal with heavy dockets of the court, etc. But I think it is still kind of fledgling. We need to have good binding conventions to which most of our countries are signatory, so that we achieve a system where there are no hackers, no breaches, no leaks, or minimum at that matter, and nobody is able to steal your credit card here or there. These were my preliminary thoughts which I wanted to make. Back to the organizers. Hello, can you hear me?
Sir?
Yes, madam. So I said back to you now.
I know, I got it. Sir, it is such an enlightening perspective that you have given. We were also going to debate through the course of this panel discussion about what you said in terms of a global law. But sir, I'm also an international law student. In terms of efficacy, unless it is translated into the national level, how would it be controlling the damage, or how it will be advancing the remedy, are the crucial questions. Let us see how the other panelists respond to some of these points you have raised, even about arbitration that you said in terms of dispute resolution. Now with the pandemic situation, we must be used to online dispute resolution mechanisms. Now with that in the background, I would invite Advocate Parag Tripathi to share his viewpoints on some of these issues raised, especially coming from the Harvard background, etc. I would also challenge Advocate Parag Tripathi to look at the issue of how would you respond to this, what UNTAD raised as a concern about developing countries. You know, the way the developing countries are being affected, the issues of gender, the issues of the marginalized, and also the way the emerging healthcare market as an opportunity under the aegis of WTO is going to be impacted. And India's positioning in that context, or India as a service provider in the global trade context. So over to you, Advocate Parag Tripathi.
Thank you, Dr. Gurpur. My warmest good afternoon to the distinguished panelists and dear friends. It's indeed a very interesting area of discussion, that is global trade practices in the era of digitalization. You know, traditionally, successful professionals are supposed to master two elements of proficiency. One is know it all, and one is learn it all. People who are at the helm of the professional lives, like my good friend Mukul, has mastered both of them. And I had the great privilege of working with the present Attorney General. I worked in his chambers for almost 7 years. And I was introduced to the fabulous culture of the Madras High Court. And that culture is that a good junior is supposed to know it all. Additionally, he's supposed to also learn it all. Now, therefore, if there's an issue that in a partition suit, any defendant can be a plaintiff. So the senior will look at the junior and he'll rattle off so-and-so versus so-and-so, AIR, so-and-so, para page, so-and-so. That is something which I, for the life of me, could never do. So I used to carry a small book to memorize and pass that exam, which was there all the time, 24/7. Then there was the learn it all. All right, a judicial function cannot be delegated unless there is a specific statutory provision. Now this normal Mr. Know-it-all will not know. So you have to have that ability. The digital growth, the exponential digital growth and the digital revolution gives tremendous tool to the learn-it-all person and compels all of us to be learn-it-all. So that is the basic shift. You know, in ancient India, all religious texts were by Smriti and Shruti. Digitalization means I can just carry it with me without having necessarily to rely on Smriti and Shruti. So it gives me much greater time for innovation, for thinking. That is really the key of this digital development, which we sometimes overlook because it has several other great advantages also. Now, in India and in the globe, in the legal field, there has always been a very interesting transfer of technology and thinking. When I was studying in America, they were very proud of their law clerk system with their judges, both of the Supreme Court and of the courts elsewhere in the structure. Now, I always looked at law clerks, meaning that it makes it easier for the judge to write a judgment or maybe even discuss something. But the real purpose of a law clerk was a transfer of technology from and thinking from the heights or commanding heights of legal innovation and jurisprudence, which were their top law professors, to the judges and back. So this was the way of communication, two-way communication between the current state-of-the-art thinking in law schools through the top professors and its interaction with the current state-of-the-art top thinking of the judges. In India too, there has been such a transfer. Unfortunately, we have not given the kind of space and encouragement to the academia in India, which it very, very strongly deserves. There are, of course, great exceptions to top class intellectual academia, like, for instance, today, Dr. Gurpur, and many more. But we need many more such instances so that youngsters, as was pointed out by one of our predecessor speakers, the youngsters don't only go to corporate law, don't only go to litigation, but also go consciously with first choice to academia, because the real thinking happens there. And that's very important. And there, this digital technology can be a complete sea changer. In India, how did it help us? It helped us, interestingly, through the system of interns. I learned how to operate several computers and tricks of the trade. This old dog was taught new tricks by his interns and my younger juniors, because they carried it to us. And I have talked to several of the judges. That's how the technology transfer has happened to them also. So by having an intern for a month or 2 months, you are, if you are so inclined, you are really doing re-education, and that's very important. Now, coming to the issue of ODR, because that is out of the 6 very interesting, futuristic, and current topics. I think ODR, which is online dispute resolution, is one which directly affects practicing lawyers. The others do too, but this is a direct effect. What ODR does in substance is give you not only access to justice. Access to justice is a very well-known concept, but access to literally the doorway of justice. So a client who's sitting in, let us say, Pondicherry, will log in and know whether or not Mr. Tripathi has appeared, whether or not he has argued this very point which we had discussed that he will argue, how was the reaction. So he has that real-time information. There is complete transparency, and that totally helps the entire environment. Just think, today in Delhi, we are in the grips of a horrible COVID situation. Professor Gurpur pointed out that let us see how this new technology can help in healthcare. Now in Delhi, and I'm sure all of us who are from Delhi, Mukulji is there, Pavanji is there for sure. We know that every day on every WhatsApp group, we get, if you want oxygen, these are the numbers. If you want ICU, these are the numbers. If you want remdesivir, these are the numbers. You try those numbers, they're either never picked up or they are never through. What you need, government has made an effort, and we can't just blame the government. That won't be fair, because this is something which is unprecedented. As the Delhi High Court judge rightly said, who was dealing with this matter, this is a tsunami. This is not a pandemic. It's a tsunami. But if we could have a real-time website with real-time availability, whereby a click of button, you know, there is an ICU available and it is likely to be available for so long. And there, even a blockchain technology can help, because you can have a digital ledger which will say that, all right, let us say Gangaram Hospital, here are these 5 beds. Mr. Tripathi is trying to get one for his friend or whatever relative. So most likely 4. In the next 15 minutes, we expect there'll be nil. So that people don't unnecessarily go, the panic reduces. Remdesivir, well, I can't give you directly, but here is the open ledger. These are the suppliers. You please tell the doctor in your hospital to talk and the delivery will be made. But we can't give it to you personally because that's not permitted. So that way, I think it can be of great benefit to the nation. Now, let us look at ODR. The ODR's topic technically for the seminar is in the context of online dispute resolution as a mechanism to resolve international trade disputes. Now that's the area. But I think it is a great opportunity for mechanism to resolve, and I drop international trade disputes. That's it. Yes, ODR requires particularly in developing and quasi-developing countries or quasi-developed countries like India, because we are, there's a very nice Urdu couplet, na khuda hi mila na visale sanam, na idhar ke rahe na udhar ke bane, which applies to India, because we can't be called a developing country in the sense of a backward country which doesn't have infrastructure, and we are certainly not a developed country. So we are a quasi-developed country. So in this whole concept of online dispute resolution is requiring an information ICT, that is an information and communication technology framework. That is investment. Of course, in India, a large part of it has been done. A still larger part requires to be done. But what is sometimes overlooked is that it does away with a lot of brick and mortar expenditure and infrastructure, which makes it much more accessible and much more friendly to a person, let us say, who is joining the profession. Today, you would need a swank office if you want to start as a litigation lawyer, at least an office, forget swank. You need an office, you need the office equipment, you need the ability to communicate, to physically reach the court. Therefore, you need that office in a vicinity of the court, so on and so forth. With ICT in place, all this brick and mortar infrastructure is done away with. The physical library is done away with. So even in a small cubicle, say of whatever, 10 by 10 or 15 by 15, keeping the COVID distance in today's world in place, by 15 by 15, you have control of everything. So this is a great opportunity. As Mukulji has said, that we have had that experience in the Supreme Court and the High Courts. There have been glitches. Of course, there will be glitches. No doubt about it. But with glitches comes the realization that this is doable, provided we are able to take the right policy decisions, both as a part of our fraternity, legal fraternity, and as a nation. Now, naturally, the digital technology or the digital, I call it as benevolent tsunami. This digital tsunami, but which is a benevolent one, is disruptive. The technology is disruptive because one, it shakes up the know-it-all part in us, because we realize that I may be having know-it-all till yesterday, but today morning there might be another judgment, and I have to have that skill of learn-it-all as well and see that yes, my know-it-all is upgraded to the learn-it-all, and I reach the place which I want to reach. I, for one, would not be surprised if you have, in due course and not such a faraway future, a technology where you need not even have to orally address the court. You can have voice recognition systems which will take down what you're saying. The advantage there is, again, that you have a permanent record of what you have argued, which is very important when you come to the appellate stages, saying I argued this and I argued that and everything I've argued, and you argued actually nothing. The judge said, do you have any answer? You said actually none. And then when you come to the appeal court, you get, say, the benefit of an advice of a top lawyer. So all those things come in. So this is one area. The other area, of course, is in our criminal justice system, where again, though this is a criminal justice system has nothing to do really with international trade disputes, but it's everything to do with this digital technology. You can do away with the routine presence of accused people in trial. by just having a video trial, except in very select cases of cross-examination, because the demeanor of the witness can be seen without doubt. You can see the demeanor of the witness. As I was attending a webinar where one of the key speakers was yawning away at the rate of about 2 yawns per minute. So the moderator said, well, we have heard about demeanor of witnesses, but now we are seeing the demeanor of a distinguished panelist. So demeanor is seen clearly. There's no doubt about it. And as I said, yet another great advantage can be the blockchain technology. How? Take an example of the or let's take an example of the post-digital courts. Now, supposing somebody, people like Mukulji and Pawan are always in great demand. So supposing they have 2 cases, items 7 and 9, and in the blockchain that is released. So the gentleman who is at number 8 will feel that he is bound to be there in 7 and 9. So the chances of his appearance in my case is much, much higher. So whether I'm 8 or 12 or 6, I'll rather go there. So this is, of course, on the somewhat lighter side. But on the more important side, things like availability, matters are going on. Now there are 18 matters. I'm number 16. If you have a blockchain which can be utilized, you can have a regular system where the junior counsel will say, sir, I am 14, I'm likely to take 10 minutes. I'm 10, I'm likely to get an adjournment. Look at the enormous advantage it has for everybody. You know when you should log in, you know when you should log out, and you move your litigation forward. Just, I remember one of the great judges of our system, former Chief Justice Venkatchalaya, had inducted 2 specialist additional registrars to the Supreme Court to put matters together so that they could be heard as a lot. And for instance, tenancy matters were given, I remember, to Justice Mohan, who finished the entire backlog in less than 6 months. So there used to be 4 lists: the normal list, the ready list for final hearing, the not ready list for final hearing, and the not ready list for final hearing where service is incomplete. All of them would be finished off, because by and large, tenancy matters have a limited framework. So this is how to a great benefit can come out of this technology. And lastly, which way will it go? Well, we have reached, there's a huge growth of artificial intelligence. You have, this is my pet dream, because as they say, it's not enough to ask what makes you go to bed so late. The real question, if you have to grow as a human being in your profession, is what is it that makes you jump out from your bed early every morning? Because that is the test. If you have that desire to jump out and do something, then that means you're right on. Your desire is there. So you have artificial intelligence. You have various technologies and softwares which tell a chess player how to play his game of chess. That if this man moves this is how you'll react. In my view, I know you'll probably laugh at that, but I'm very serious. In my view, sooner or later, and sooner rather than later, you will have such technologies which will tell you that if these are your fact cases, how should you plead? Whose evidence should you lead? If you are arguing, let us say before Justice X, he has this exactly like the Google and other intermediaries are set to utilize data, channel data. They would know that this judge has a predilection for this kind of a line, this kind of a thinking. So in his court, this line may be a very good idea. In this court, this line may not be a good idea. If whether it is your strategy for filing your pleadings, whether it is a strategy for argument, this kind of a technology, of course, it looks completely in the imaginary world, but I'm not at all, I'm totally sanguine that before you have your 5th or 6th such conclave, the technology would emerge. So therefore, to conclude, lastly, Professor Gurpur had told me also to check up about what about the suggestion of UNCTAD, and what about the position of a quasi-developed country like India. You see, Mahatma Gandhi had rightly said that to poor man, God comes in the form of food. So it has to be a holistic approach as far as a quasi-developed country is concerned. It doesn't help that you have at the top extremely wealthy people who can fly out of a COVID-struck India and reach the deadline in England, reaching at 3:45 when the deadline starts at 4 a.m. You need a system where there is greater growth for all, bigger size of the cake, greater growth for all. And in areas like healthcare, I've already said, the great advantages are there for this kind of a technology. In areas, you can even use a blockchain to find out when a top surgeon is available. Suddenly he cancels his vacation and comes back. You can utilize. Therefore, these are all areas which require innovative thinking, out of the box thinking, so that we shift from a know-it-all to a learn-it-all and know-it-all combination. That, according to me, is the way forward. Thank you so much.
Thank you, Advocate Tripathi. The very, very rich insights. And there are three main takeaways from your position. One is the way in which online dispute resolution per se can be the future and what are the advantages. A lot of insights on strategizing. I mean, these are great learnings for budding lawyers. Also about how there can be a kind of holistic policy or system emerging. Now, with that very rich insight, we should proceed to the other speakers. Meanwhile, I'm very happy to share with all the esteemed panelists that you are being listened to and watched by 1,000 plus students and other audience from across the world, maximum from Symbiosis Law School, Pune. That shows that you all are what you call rock stars in the eyes of our students, because this is something they look forward to. It's to the teachers' envy and to practitioners' pride that we have such a whopping presence of audience. Now, against this background, if I were to invite someone to talk about some of the angles that came from both Advocate Rohtgi and Advocate Tripathi, I would look at the dimension of what would that holistic policy look like in the particular context of big players, the big techs. So I would request Advocate Pawan Duggal to come in line and share your wisdom. Only thing is we have to really regulate the time. So if I request you all to not to take more than 7 minutes so that we have another round of responses. I've got my co-moderator, Dr. Bindu Ronald, with me, who may give you another 2 to 3 minutes of response in case I'll have to leave the dais for my other presentation. So I request Advocate Pawan Duggal, and at the end of the 7th minute, I may remind you if it is okay, because I myself, I have a weakness for talking, so it happens. So with that kind of disclaimer in advance, I request you to share your views, please. Advocate Pawan Duggal, I think you're muted.
Can you hear me, please?
Yeah, now we can, please.
Thank you, Dr. Gurpur, distinguished panelists, Mr. Rohtgi, Mr. Tripathi, jurists, friends. 72 hours back, the European Union has now come up with a new set of proposals. These proposals are ultimately aimed for coming up with an Artificial Intelligence Act for the European Union, where they are, apart from other things, not only trying to regulate artificial intelligence, but are also specifically trying to elaborate the rights and duties of service providers. From this scenario, let me take you back a couple of months back or years back to the Christchurch attack that took place in New Zealand. Now, this particular attack was beamed live on Facebook, and that shook the entire collective conscience of the world. Now, the viewpoint of the service provider was that I could not do much. The moment I came to know about it, I put it down. But the subsequent events of the Christchurch declaration clearly put into the focus of the fact that today these big tech companies are not just big companies. They're not just tech companies. They are governing our lives as they are humongous data repositories. The kind of information they have about ourselves is far, far more than even our own parents, our own families, and our own spouses as well. So somewhere down the line, the ball started rolling with the Christchurch Declaration, whereby New Zealand took the lead in saying that, look, it's time that we should start reining in these big tech companies and making them more accountable. When I go back to the realms of history, the initial processes that were started by the Communications Decency Act in the US still continue, but those have been primarily the predominant colors that have been actually coloring the global landscape on the liabilities of these service providers. Section 230 of the Communications Decency Act in the US granted complete immunity to all service providers. And by and large, this has held through so far. A lot of countries were influenced by the American model and came up with similar approaches on intermediaries and their issues. It's only now with the Christchurch Declaration did we see last year some major developments taking place. President Trump actually started and passed a new executive order by means of which he actually asked the Department of Justice to relook at this entire issue of intermediary liability and making them completely not liable under Section 230 of the Communications Decency Act. Now, while all this was happening, India was slowly but surely on the sidelines, trying to watch what's happening. But ultimately, there were some tipping points which really started a huge kind of a humongous ball rolling. And that was in the form of, first, the WhatsApp amended privacy policy being thrust into the throats of Indians. And then a couple of other initiatives which primarily convinced the government that the time has come that we should now regulate these big tech companies much more effectively and efficiently. Mind you, the Indian approach on regulating these tech companies are still governed by Section 79 of the Information Technology Act 2000, which by and large makes them not liable for third-party data or information made available by them, provided they are complying with certain basic parameters of the IT Act and rules and regulations. But come 25th of February 2021, and the legal landscape in India completely changed. We actually now saw the government actually implementing the Information Technology Intermediary Guidelines and Digital Media Ethics Rules 2021. Now, these rules have repealed the Information Technology Intermediary Guidelines Rules 2011 and have completely laid down a new color into the landscape. And the color is that now the law is far more stringently looking at big tech companies. These rules are telling us that if you're a big tech company, you are an intermediary. If you are an intermediary, please comply with the IT Act and the IT rules, especially IT Rules 2021. You don't comply, just tighten your belts, because now you will be criminally liable for being prosecuted for offenses under the Information Technology Act 2000 and also under the Indian Penal Code. So that effectively, when I read that with Section 85 of the IT Act, it's very clear the company cannot be sent to jail, but every person who's responsible for running the day-to-day affairs of the company or responsible to the company for managing its affairs actually becomes within the ambit of criminal liability. Now that's created still some furor among some circles, but by and large, the majority of the intermediaries are still sleeping. Last week, we found yet another landmark judgment coming by the Delhi High Court, where they upheld the entire issue of criminal liability of these big tech companies if they failed to remove certain offensive or certain obscene kind of a content. But I think that's only the start of a journey. The fact still remains is that today, big tech companies need to be reined in. You cannot take the argument that I'm in one particular jurisdiction, I'm located there, and hence I will not necessarily be in a position to comply with your specific rules and regulations. Now that argument has been rejected in Singapore, in China, in France, and now it's also being rejected in India, thanks to the IT Rules 2021. But I think we have to go far beyond. One of the primary uniform approaches that these big tech companies take is that, sir, you are increasing my compliance costs. For every new jurisdiction, I'll have to do independent local new compliances, which may not be very, very feasible from an economic standpoint. But I think ultimately the jurisdictions are very, very clear. You will have to increasingly start complying with our laws. If it's not suitable to you, you can please leave away our respective jurisdiction. I've recently written a book called New Cyber World Order Post-COVID-19. In that book, I've said that by the time the countries are successful in the fight against the first and the subsequent waves of COVID-19 infections, we would enter into a new cyber world order. A new cyberspace is awaiting us, where the ground realities will be completely changed. The states will become very powerful. Cybercrime will be the default options. Cybersecurity breaches will be the new normal. And there will be increasing interference in individuals' enjoyment of digital rights, apart from the world likely to see a migration of users from the superficial net onto the dark net. In that particular book, I've specifically also argued how now states in this new cyber world order are likely to tighten the screws as far as big tech companies are concerned and making them more responsible and liable, and logically so. I mean, with the coming of COVID-19, we've begun to see the golden age of cybercrime, which has already begun. The kind of cybercrimes that we have seen in the last 15 months, we have not seen in the last 50 years of the advent of the internet per se. The last year, 2020, the world lost more than $6 trillion as damages due to these cyber crimes and cyber security breaches. This year, the figure should go up to more than $8 trillion. So in a scenario like this, I think the big tech companies clearly have a very, very significant role to play. The honeymoon period is over. That's a message that's very, very clear on the wall. When I look at these various coronavirus legislations that have been actually passed by different countries from the time the COVID-19 came across, apart from doing various actions under the garb of fighting COVID-19, there are increasing regulations that are now coming in, which are mandating stakeholders, players, entities, intermediaries, and service providers to do a variety of stuff, including the fact.
Thank you, Advocate Pawan Duggal, for the time being, and we will pick up the strands from your exposition. You are always innovative in coming out with the comprehensive book or writing about the futuristic dimensions, like your book on mobile telephony, or much earlier you were one of the experts on cyber law, and now you're talking about cyber world order. So in this context, I would like to divert the discussion to the idea of impact of cross-border mergers and acquisitions in this context, and the work of big technology impacting in terms of the regulation that you spoke about, how it is going to impact in terms of technological innovation. I would request Gauri Gokhale to come in, because she has been very, very instrumental in some of these policies, and she is an IP expert. We have our own stakeholder and part of the organizer team, Supratim Chakrabarti, who can speak on all the dimensions once we cover some of these guest experts. I'm sure he must be very much eager to speak, because he has lots to do, because he has worked closely with the Justice Mudgal Committee as well, I remember. So now I would invite Gauri Gokhale to respond, please.
Sure. Thank you, Madam. Thanks for the distinguished panel and the jurists who are sort of attending this session. Thanks for this specific question on mergers and acquisitions, but I just want to sort of spend a couple of minutes prior there to in so far as the holistic digital topic as a whole, right? I think what we have realized is that the entire humanity is now more and more getting dependent on the technology. And before the machines take over the humanity, I think it is time for us to sort of take a step back and visualize where are we going with all this. There is overall what I've realized is that as lawyers, we can't be just focusing on the legal aspects when we are looking at this entire development. What I've realized that understanding of technology, understanding of constitutional issues across the jurisdictions, ethical issues, because a lot of this ultimately will boil down to ethically, how things should be done or ought to be done. That is why you're noticing a lot of discussion of ethics in AI, because sometimes law cannot necessarily address everything, and ultimately you have to see ethically what is right in that context as well. as also philosophy, psychology, sociology, economics. I think all these faculties have to look at all the discussion points that all the panelists have put, across for us together. We can't look at now things in isolation. And I agree with Dr. Bennett when she mentioned that whatever, you come across, you have to look at, all these different facets together. And, ultimately you need to connect the dots. On the aspect of, I think, global, sort of, platforms and the laws, attached to that, I think it is getting difficult to say that, okay, each jurisdiction will have their own set of laws, because there are, product changes required when you have to sort of maneuver a platform to address a particular jurisdiction. We need to look at, what are the, therefore I feel somewhere the way treaties or otherwise need to evolve, as we saw under, for example, trips gave you the minimum standards for protection of intellectual property. So over a period of time, for all the facets that we discussed, can be developed certain treaties which are at least giving you the minimum standards to comply. And I have also realized when we are, when we try to sort of, advise the clients on the compliance of the laws, what I've realized is that the lawmakers are looking at the laws in a particular, with a particular business model in mind. And what happens is the business models evolve on a daily basis, right? So when the laws give you minute details from a compliance perspective, the business model or technology has already moved on. So I think somewhere when we are setting these global laws, can we arrive at the principles that have been provided and rely more and more on self-regulation, where the industry is able to understand as to how to apply that principle to a particular technology, right? And then, take it from there. I think some of these are my initial thoughts, but when we get into question answer on more details, I'll deal with them. But coming back to your merger and acquisition, honestly, I think the way I look at this, right, any of these legal developments, I feel that we should look at, can there be a problem solving that we are providing to the humanity? And when we look at these mergers and acquisitions across the countries, can we look at that these big tech companies, in the context of big tech companies, can there be synergies between various layers of technology companies, where we are giving solution to the basic human problems to begin with? Can there be, for example, India, just to illustrate, we know that India, people always say jugaad inventions, right? Can there be these type of sort of startups work with, I'm not necessarily talking in the mergers and acquisitions, the corporate kind of a kind of a setup, but can there be collaborations, right? Can there be some of these elements where you have sandboxes where startups and the big techs are working together and are able to provide solutions to the water problem, to agricultural problem, to basic the blockchain, for example, that was mentioned, can that be used to solve the reach, the problem of reach that we have across the country, right? So I feel that merger and acquisition for sake of simple merger and acquisition, or for sake of simply acquiring the technologies, uh, rather than looking at in that context, can we look at developing across the jurisdictions, developing platforms where these parties, whether startups, big techs, are coming together and solving something, for the country, right? Or for a particular country, or for the humanity, or otherwise. I would want to see whether that kind of a setup is possible. There are certain mechanisms that are available, but that is the way I would want to look at, and leave thought to everybody, that can we look at the synergies to solve something, and in that context look at mergers and acquisitions, and not simply to just be like enhance the economics for the that particular company. So I'll leave these thoughts with you all. And the other point that I wanted to mention, especially in the Indian context, I think Mr. Duggal also alluded to, and I have had the opportunity to sort of interact with both the ministries, that is Ministry of INB and the Ministry of IT, in this context of this legal developments that we have seen in the last couple of years, as well as with the industry. And I think what the government is now seeking to do is basically come in and say that I need to protect my citizens, right? How can I protect my citizens? And in that context, all of us need to look at it. I don't think, and yesterday itself, I attended a session by METI when they were talking about, whether this is criminal liability or otherwise. Their simple underlying statement was, we want to protect our people. And all of you need to come in and help us to protect our people. That was the underlying score. It was not that, okay, we want to punish somebody, because we know that in the, in my mind, criminal, sanctions or otherwise are not really giving you a solve in the country or otherwise. What is required is that essence that, okay, we want to behave ethically. If the law is gray, if I hold my hand to my heart, what I feel is the right thing to do, right? If all of us look at the law in that context and not look at minutely commas and full stops, but see what really ought to be done in the context of where we are, I think that is what will give solve to a lot of the issues that the panel members have put across for us. And happy to take further questions on any of the topics going forward. Thank you. Back to you.
Yeah, Madam Professor, I'm Mukul Rohatgi. Can you hear me?
Yes, sir. Yes. Yeah.
Yeah, Madam, I have unfortunately to log off. There has been an unfortunate development. Justice Shanta Gowda of the Supreme Court passed away late last night. So there is some condolence at 2 p.m. So kindly.
Yes, sir. Respectfully, we started
Yes.
whole function.
I know. So, Madam, kindly excuse me. Kindly excuse me. I have to go there. Thank you very much for these lovely thoughts. And as I told you, I am a novice. And if I may tell you a secret, Pawan Duggal is the man who really knows this branch inside out. He has been opposing me in a case. So please don't allow him to leave. Thank you.
Surely, sir. Thank you, sir. Thank you for all the support, and
Professor
thank you,
Gurpur,
sir, also.
I make the same request.
Yeah, I did that. Yeah.
Particularly about my good friend Pawan, because I and Mukulji were in the same case on one side where he was opposing.
That's great to hear.
So
Pawan is our advisor. Dr. Pawan is a great friend and advisor of
Thank you
Symbiosis.
so much. It's great.
Thank you so much, sir. We request you to collaborate in future, both of you, to develop our students and act as mentors. Heartfelt thanks on behalf of ourselves, our students, Symbio committee, and particularly Parantap and his team from the Conclave and from our top management. A big thanks. Now, after Ms. Gauri's learned exposition, where she has even finished precisely on time, that's a great mark of efficiency and precision. I would request Professor Tachik to come in and respond to the two ideas. One is, where are we heading in terms of human good, the dimension of justice? Should we be looking at a global media tribunal or media court in this context? Should we be looking at a global data policy? What would that policy look like? What should be the underlying principles of that policy, or what we call as the architecture of that policy? Over to you, Professor Tachik.
Thank you very much. Let me begin with a word of thanks. It's always a privilege and honor to participate in all the events organized by the school. So thank you very much, Professor Gurpur, and all the team for the invitation to this event. Well, we're trying to address the questions that you have raised. I would begin with a sort of theoretical perspective. I'm an international lawyer and human rights lawyer, and this is the perspective that I have while looking at data protection. The first thing is that I believe that before trying to answer where we are heading, we need to think a little bit about what grounds for data protection laws we are trying to invent. Because we can look at data protection laws from different perspectives. First of all, we might think that data protection stems from human rights. And of course, there is a lot of good arguments for that. In the European context, you might see that data protection, at least under the framework of the European Convention on Human Rights, evolved somehow from Article 8, protecting the right to private life. Within the European Union, there's also this sort of lineage from human rights to data protection laws. But there's also a different lineage in data protection, the lineage of private law, of civil law. And of course, these two pedigrees, these two lineages might fruitfully coexist and intersect. But nonetheless, I believe that sometimes there is a need to choose a proper paradigm in which we try to think about how to protect personal data and how to protect privacy. Because from the perspective of private law, our personal data are a sort of an asset that we dispose of and that we engage while taking part in the commodity exchange or exchange of services on the market. Of course, in this perspective, individuals seem to be less protected because it is surmised, as it usually is in private law, that basically every individual actor takes care of his or her own interests. So of course there needs to be a certain legal framework, there needs to be a certain judicial framework in order to protect privacy and in order to protect personal data. But nonetheless, every individual is believed to be a conscious actor. And if we engage into the exchange of commodities or services, we somehow bear the brunt of this exchange. From the perspective of human rights, the situation is a little bit different because when data protection is believed to be part of the right to private life and to be protected as part of the global framework of human rights, well, in this case, they need to be safeguarded regardless of anyone's participation in the commodity exchange in the market, and regardless of our knowledge, engagement, and the ability to defend ourselves. So that's a very crucial question that we need to answer when we think about the global system of protecting human rights. It's the choice of these paradigms is very visible when we analyze the concept of consent. Of course, consent is one of the crucial institutions in the data protection laws. But of course, it is hard to say what a consent truly is. The consent to share and to allow our personal data to be stored and to be used by other actors. As Justice Bennett already mentioned, it's often the case that we consent to have our data shared and used, even though this consent is pretty artificial. So we are presented a long list of conditions that we do not have the time and to read, and we don't want to spend the effort to read them. So we just accept them. And of course, it is assumed that this is the expression of consent. Another thing is that in times of COVID, we are also forced to express our consent when you're employed and when your employer wants you to use media platforms and streaming platforms in order to communicate with other employees. It's really not up to you to express consent, of course. So this consent is somehow forced. And now the crucial thing is just to answer what this consent should truly be. And of course, it's not only the matter of safeguarding proper conditions and legal regulations, but it's also a matter of education, of allowing the people to know that they have certain rights to have their data protected, and that they have the right to express consent freely. And of course, the crucial question is how much responsibility should lie on state institutions or on international institutions. If we are closer to the human rights paradigm, of course, the stress is more on the protection safeguarded by independent institutions or of the state or international ones. If we are more leaning towards the paradigm of private law, well, in this case, it is assumed that more agency should lie on the shoulders of individual actors, and they should be allowed to have the data protected. But what they do with that, it's up to them. And of course, now the question of some kind of global regulations of data protection. This is a very fragile and multi-dimensional problem. In a sense, we can observe that the process of internationalization of data protection is taking place. Right now, it's taking place mainly as a result of the activity of the European Union, which in the GDPR decided to impose a certain standards that will emanate to other parts of the world. And of course, this is very problematic in a number of reasons, because on the one hand, there is this very optimistic perspective in which you say that the European Union managed to produce some kind of a well-developed instrument for data protection, and now everyone in the world will benefit from that. But of course, under this optimistic narrative, there are also some darker aspects, because right now the European Union is in a sense imposing standards for the entire world without any sort of international consultations, without any sort of global perspective with that. Of course, we know that the EU negotiates some agreements, as it did with Japan, and of course there is some kind of agency of other countries in this. But what we need to be conscious of is that perhaps the time has come to for a more concerted action and effort to produce some kind of international framework of data protection, in which the EU would no longer play the role of some kind of unilateral producer of standards that are imposed on other countries of the world, but would rather be an equal partner. And of course, it also raises a number of questions, because if data protection laws are part of the human rights framework, the obvious question is, why do we pay so much attention to them and to safeguarding them on the international level, whereas human rights still are underrepresented at the international level? Of course, we have some bodies, we have the UN committees and bodies that look into respect of human rights, but how come that suddenly data protection becomes the most crucial human rights in the world, given that there are, of course, many other much more, you would say, substantial and crucial human rights? And by saying that, of course, I'm not going to belittle data protection, which is absolutely crucial. But,
thank you, Professor.
Yeah.
Alongside data protection, confidentiality, and this idea that you said, the rights of the people in a global legal architecture become so important. Is there any other one point you would like to add so that we move to the other speakers who are going to again unveil the dimensions of technology and global trade in terms of finance and cloud services and consumer protection, which is in a way aligned with what you're talking. Yeah.
Mm-hmm. Yeah, I would just conclude with saying very briefly, and sorry for talking for too long, but of course I would argue for some kind of international institutions that would control data protection, and that would be strong, because human rights are always as strong as the institutions that are safeguarding them. We can have wonderful instruments on paper guaranteeing plenty of rights, but without a very strong framework of guaranteeing them, we would not be able to move forward. So that would be what I would like to add. Thank you.
Great. So now it is my turn. Sorry, I should be having my video on. Sorry about that. Now it's my pleasure to invite Advocate Arun Prabhu, who has been representing these global big techs, who has been also advising them, and who has been very much involved in legislations and litigations involving upcoming issues of blockchain, upcoming issues of big tech players. So would it be appropriate to invite you to give some of the dimensions in terms of iCloud services, or what we read about what's happening in Kosovo in terms of consumer protection, many countries going in favor of legislations, the role of artificial intelligence being brought into service. Could we hear from you, Advocate Arun Prabhu?
Sure. Thank you, Dr. Gurpur. And it's not fun to go this late in what is an exceptionally well-informed and diverse panel speaking about topics of such contemporary relevance. But I'd like to take off from what Mr. Duggal said, as we often tend to do in this space. I think what we're seeing in terms of the international trend around regulation and domestic trends in India is not an unusual set of circumstances. What we're seeing is the discovery of a valuable set of resources, the gold rush, so to speak, and the expression of both private and state actors in trying to understand and claim property over the results of this gold rush. And that flows across all of the themes you've made, whether that is the beneficial effects or the results arising out of artificial intelligence, whether expressed by way of identifying and diagnosing new diseases even before the medical practitioners can spot them, or identifying who the protester is in a large crowd of people all wearing face masks, or whether it is in the operation of distributed ledger technology, whether enabling all of the various use cases in which the learned senior speakers before me have sort of alluded to, or enabling terrorist funding because of the inability to track the sources and the absence of a single ledger. To my mind, there has always been and there will always remain a balance between the need to control and own a resource and its ability to evolve and be delivered in diverse ways, as has been the case with intellectual property, as has been the case with software and copyright licensing, as has been the case with data, and as is now the case with algorithms and AI. We find that there is a tendency to treat the resource as being finite, because the human mind works like that. You see it as being finite, you see it as being controllable, you see it as being necessary to regulate. And at the same time, you find resources which are increasingly not amenable or increasingly difficult to fit within that paradigm. And often, both as practitioners, as litigators, as people who advise the entities who deliver novel services, which we at least haven't thought of, we have to grapple with this because it is very much a case of fitting a square peg within a round hole. Now, sometimes we see elements of that friction very evidently, as we are seeing with cloud. When having stood in many data centers with the CEOs or the country managers of large data center providers, and surrounded by policemen asking them to give some information on an encrypted virtual machine which they have no practical way to access. I think what happens when you try to fix novel technology or novel delivery in a conventional paradigm is a certain lack of trust, a certain lack of faith, both from the regulated and the regulator, which is only exacerbated by silly arguments like, oh, go get an MLAT request. We don't have a substantial business presence in India, so we can't help you. Although 50% of our sales globally are in India, etc., etc. And what we're seeing in India, of course, is some amount of sanding away of the edges. And we're seeing overreaches on both sides of the table. We're seeing providers trying to overreach by trying to prefer contractual restrictions, often flimsy contractual restrictions, which they overcome in other jurisdictions, over the law of the land. And we see regulators creating legislation which patently violates the principles of constitutional protection and privacy, which have been laid down, so memorably in our times in Puttaswamy and the judgments that succeeded.
Yes.
This issue is exacerbated, obviously, by points of technological inflection like the COVID pandemic, when the contrasts between making an essay, and as we're seeing today, making criticism or an image of the inadequacies of the government around us evident on social media, as opposed to protecting the sovereignty of the country, are becoming increasingly evident and increasingly difficult to balance. increasingly becoming issues on which we feel very strongly and very emotionally, given that we see people die around us, and increasingly becoming difficult to look at from an existing legal framework. So I want to conclude by really saying that delivery of technologically innovative means of services and products are going to be subject to a certain level of regulatory friction. They are going to be subject to overreach. They are hopefully, and I pray this is true, going to be subject to some judicial regulation and reading down of some of the overreach. But what we are going to end up, or going to have to end up with, as we have in so many other spaces, as in competition law, in the regulation of corporate behavior around the corporate veil, around the regulation of international funding and the funding of non-profit organizations, or around international trade. And I think the topic for today draws those parallels for us. We are going to have to find what is a workable balance. And that workable balance will change depending on how concentrated power is, in whether it is in the center or in the state, and how important an economy is. There is a price to be paid for participation in all the major economies of the world. And we are in an economy which I think one of the learned senior counsel put very well is in sort of this Trishanku zone of going from an underdeveloped economy into being a developed economy, and is slowly starting to flex its wings. Will it do so in accordance with the rule of law, in a manner that we will find sustainable to justify to generations that follow us? Or will it follow a knee-jerk, principles-driven approach, which, in retrospect, we will all look back and say, oh, I wish there was an ADM Jabalpur around this point in time. I don't know. I don't have an answer. But all I can say is that, this room of people is often at the tip of that spear. And it is useful for us, especially for the law students in this group, to look at not just trends in India, but trends in China, trends in Russia, trends in Singapore, as indicative of the flow of the tide when you turn into legal professionals who are advising people bringing in innovative technology. Thank you.
Thank you, Arun. You have in a way translated the theoretical dimensions and overall jurisprudential observations of Professor Tachik into reality in the comparative jurisdiction. Taking forward some of the clues that you have given in the context of big technology and online data privacy and larger issues of global data privacy legislation, I am inviting Supratim, who has worked with the Justice Sri Krishna Committee and who has been a very vibrant speaker in many of these related areas, requesting him to look at three things. One is, how do we look at harmonizing the data privacy law, taking further what where Arun has left from. He pointed out Singapore and all these places. Whether online big data players, these big tech companies and their activities, are they fully beneficial, or what are their impacts? Especially with their enormous power on business, because they have our data of our customers, they have the know-how of our business, because IT is the lifeline, technology is the lifeline. So on businesses, on market, and now on democracy, as earlier speakers like Pawan also pointed out, the advocates pointed out. So in this case, whether the consumer of such big techs, should they have a default setting, or is it a turn on, turn off kind of setting to sacrifice their data or surrender their data? For me, it is like surrender of sovereignty, as Arun also pointed out to the Supreme Court judgments on data as an organic entity. So how do you think we can visualize legal infrastructure globally and a harmonized data privacy policy? Over to you, Supratim.
Thank you. Thank you so much, ma'am. And thank you to Symbiosis Law School for calling me to this August gathering. And it's a privilege, really, listening to all of you. Like Arun mentioned, being the last speaker, I think my job is pretty much sorted, because most of the things that I wanted to speak on has been spoken about. So I'll keep it very brief. And like ma'am said that, having very closely worked with Justice Sri Krishna, some of these deliberations across the country that I have attended was an eye-opener, really. Okay, for example, when we were discussing about consent, we discussed that what is real consent in a country like India. where there is such large illiterate population, where people are speaking so many languages. The application that you see today, you just see, say, a 50, 20 page terms and condition, and you say, I accept, I agree. Even the literate people are not going through. Forget about the larger populace of our country. Are they really, educated, or are they aware of what they are agreeing to? Anyways, coming to the two, I think, couple of points that have been put to my platter. One is harmonizing data privacy laws. I think this point was being well spoken about by my earlier speakers. Is it possible to harmonize? The answer is yes, because see, some of the global gold standards can be easily adopted across all countries. Okay, so where is the problem? Possibly the problems are fivefold. One is absence of or lack of regulations across many jurisdictions. I think about 19% of the countries do not have a law as of now on data privacy and protection. Second is different constitutional framework, okay, which makes this slightly difficult. Third is divergence in practices locally, either through the big techs or what has evolved within that nation. Next is surveillance by the nation states, by the government, which creates a large degree of disparity. And after the Schrems case, we are observing what's happening around the globe. And the fifth, then the most important thing, is political will. Okay, we have observed in the most sensitive of cases, information being stuck in the MLAT process, Mutual Legal Assistance Treaty process, which could run up to, I think, approximately about 11 months at times. Okay, so regulators who really need the information quickly, say from a foreign jurisdiction, are not getting it. So that's a quick take on the first question. On the second part, because so much has been spoken against a sort of big tech, and possibly Arun brought a middle ground, just for the sake of argument, I am inclined to give a different perspective to this discussion, and that is that do not demonize big tech. Okay, I think somewhere we are being too negative about whatever they are doing. Okay, when I met with the ministry folks, when this personal data protection bill was about to be tabled, and they asked me a few questions. When I sat across the table, I just told them that before you roll out these laws, there's a lot of inward looking exercise that needs to be done. There's a lot of homework which needs to be done by the government, by our policy makers. For example, we talk about data minimization a lot, okay? But how many of our laws do come with an expiry date for information or data, or deletion of data? So out of fear, we are endlessly storing data. So these are things perhaps which the government now need to look at with a more stricter lens. There are several such examples which is required to be done by us. And there was a question on having, I think Gurpur ma'am, you raised the point that we need to have local legislations as well, which are in sync with these global standards. So for example, since August 2017, ma'am, we are trying to have the personal data protection bill. So you can imagine how long it has taken, and it is still not tabled in the parliament, or debated in the parliament rather. So this is the state of affairs in our country, where we are still dilly-dallying on such a critical legislation. And what I hear, and this is absolute grapevine, is perhaps we will have a bit of reworking on the present draft. If that's the case, then we are further delayed. In the words of Justice Sri Krishna, he said that I was about to fly out to the US, and I got a call from the law ministry, and he said, minister, said that आपको देश का एक काम करना है, and you need to urgently pick up this matter to be the chairman of the personal data protection bill framework, and you have to prepare this. So he said that I agreed, and I later on realized why this was being asked, because I think the government was getting pulled up in the Supreme Court in some matter. And I think Thursday, Friday, Justice Sri Krishna agreed. On Monday, it was told to the Supreme Court that do not worry, sirs, we will soon have a law in place. So from August 2017 till today, if we do not have a law in place, what Justice Sri Krishna feels, at least, is that we are really denying the right to privacy of every individual of this country. And this is far too delayed. Taking, my parting comment on this discussion would be, whilst we are observing that there is a lot of difficulty, a lot of excess being brought about by technology, but at times technology itself could be the solution. I'll give you a simple example to understand this better. The European Union General Data Protection Regulation wanted to give the right back to the individuals or the data owners, and so that they have control over their information. Many organizations there have started having dashboard system, okay, which is a technology driven solution where you can go to the dashboard, given your credentials, and get into the system, provide all the details that are required for your credentials, and then rectify the data of yours, or correct, edit, delete, put, request, etc. So if you see, this is largely automated right now. So technology itself could bring in a lot of solution. Speaking, in my very last sentence to the larger audience and to the student community especially, there is a huge dearth of legal experts who understand technology well. So my suggestion to the student community here would be, understand the technological aspects and put legal elements to it. And like Arun mentioned, it's not about your jurisdiction. It's about every single jurisdiction that you can think of. Look into their practices and procedures. This will take you far ahead, open up your minds. I'll give you another linked example, this GDPR related example that I gave, that you can have a dashboard. We observed that in European Union there was a lot of data theft happening because of such a dashboard, because the credential obtaining was not being done properly. So a takeaway for us, which we are about 2 to 3 years after GDPR, okay, we are behind them. So these learnings, you cannot make all mistakes by yourself, right? So you can learn from these mistakes which have already been committed and have a system which is robust enough and is more well-oiled and efficient to go forward. Thank you, ma'am.
Thank you, Supratim. With that, we come to the end of responses of the panelists to the various concepts. So we have unveiled all the concepts. Now, we this time did not introduce this polling criterion, but audience are nevertheless open to give their views in the chat box whenever possible here. And then we have a question and answer session. Before we break for the question and answer session, since we have many experts on the panel, I'm throwing open 2 questions. And I request each of the panelists to respond in a minimum of or maximum of 1 minute on these 2 questions. First question may be very pertinent to Indian practitioners. What is going to be India's opportunity in digital trade and e-commerce, especially with the service exporting, which is going to be coming in an aggressive way in the post-COVID world? Second is going to be, do we need an online global media tribunal? Will that be a good proposition? So online global media tribunal and India's opportunity, or maybe world's opportunity, because in the light of sustainable development goal, when we talk about people's rights with the inequalities in the world, as Professor Tachik said, we have to look at maybe opportunities of many countries in terms of service exporting in the digital trade and e-commerce possibilities. With that, I hand over the podium to Dr. Bindu Ronald, because I have to break for another conference. And she would moderate these questions in moving the baton from speaker to speaker and ensuring that every speaker gives the view on this. And I take leave of you. Thank you very much, all the panelists. I learned a lot. It was enjoyable. And I was being a little bit very strategic in focusing certain people on certain issues. But you get your 1 minute where you can speak what you could not speak, or if you couldn't give firm views. I thank the organizers, I thank the Conclave committee, and I immensely thank the audience. I request the audience to participate in question and answer once this 1 minute round gets over in about 6 minutes. Thank you very much.
Thank you
Dr.
very much.
Yeah, please.
Thank you very much, Dr. Gurpur. And
I take leave of you all. Thank you. Kindly permit me. Bye-bye.
Thank you, ma'am. Dr. Gurpur has put open to the panelists 2 questions. One is, what is going to be India's opportunity as far as e-commerce is concerned, especially when we look at the post-pandemic situation? And do we need a global tribunal that should be there? And I put this question first to Advocate Pawan Duggal. So what is your take on the first question, which is on what's going to be India's opportunity as far as e-commerce is concerned?
Thank you, ma'am. I think India's opportunity is immense. More and more people have come onto the digital bandwagon during COVID-19. And now this is a new reality which we have to live up. Not just e-commerce, but online education. So the pie is going bigger. So opportunities are massive and immense. Suddenly, the Indian online economy appears to be growing more mature because with more users coming in, with more demand, we are going to see far more new opportunities. So all owners will be on how quickly various stakeholders will be able to get their hands together for the purposes of trying to make the maximum utilization of this particular great opportunity. I think here is a wonderful opportunity for India to demonstrate its market leadership in the e-space, in the electronic economy space. And in case if we are able to provide that wonderful opportunities of growth to a lot of e-commerce companies, I think that is a wonderful direction where India and Indian stakeholders need to work on. Thanks.
Thank you very much, sir. You very rightly put it that the pie is growing bigger and there is a slice that is there for a lot of people in this. May I request Advocate Gauri Gokhale to give her comments on the question?
So I think I look at, e-commerce is in much wider respect, right? When we say, it's basically, I think what we saw is that, the digitization is a great leveler, right? For everybody across, different stratas of the society or even different parts of the country. So we definitely will see the benefit if we are able to sort of, work even at the state level, at the district level, to connect the vendors, the service providers, etc., to the overall platform. I think that will be a great sort of reach that can be provided. And of course we need a physical infrastructure also to support that growth. But I think I want to dwell upon a slightly different aspect when I think ma'am mentioned as to what can we export, right? And I feel that especially, during the pandemic, we have realized, the importance of soft power or the soft skills, right? So I think India can definitely, through the digitization or otherwise, can provide. We have so much of wealth in terms of, for example, for mental health or otherwise. We can definitely have great professionals, in India, or even, yoga itself has been a sort of, one of the services, as we can see, that India has provided. And when I say service, I mean in the context more service humanity, right? So some of these elements also, I think Pawan Dugal sir mentioned about, education. So in that context, I think India can definitely contribute a lot. And now with the, increased use of the digitized platforms, I feel that is something India can absolutely contribute for the world.
Thank you, ma'am. I think you were right when you said that there's a lot that India can contribute, especially when we talk about the soft skills, etc., that is there. But you also put in a very, very important point there, that there is also a need to ensure that the physical infrastructure is taken care of. There's a need to connect the people, connect the vendors to the people. So that's a very, very relevant and pertinent issue that is there, that we see when we talk about India's position as far as e-commerce is concerned. May I request Mr. Arun Prabhu to put forth your comments on this question on India's take on e-commerce?
So I'm actually going to address the broader question of an export of services. Because unlike the export of goods, which China did very well by being generic and cheap, the export of services requires particularly high value services which are backed by intellectual property and platforms of global stature, requires that those services and those platforms be globally competitive. I think this is the largest casualty or the largest cost of data balkanization and the creation of a walled garden ecosystem in India. The more there are, we deviate from internationally acceptable standards of regulatory requirements, disclosure, classification, dispute resolution, grievance redressal, all of the various things that you've seen in recent legislation, the more you risk creating a variant of a service, or for that matter, content restriction by saying you can't talk about a whole bunch of things. The more you risk creating a variant of a platform or a service which is not internationally competitive, which is not internationally valuable because it has never had to compete internationally and live safely in a walled garden. China found this out with reference to several of its platforms or services. And I fear that we in India may do so as well. So while I'm a huge fan of Indian ingenuity, I'm a huge fan of the diverse demographic and the sheer intellectual horsepower that we can bring to bear on the global services market, I feel that the creation of walled gardens is going to be a factor that starts militating against us increasingly over time, both because of the incompatibility of what we create and because of the inevitable flight of innovation to other jurisdictions. That's what I had to say.
Thank you. Do you want to harp upon harmonization in some way in this?
Yes, I mean, I see this as a corollary of the earlier one. The more you stand out from the global norm, whether that's a Section 37 exclusion from all requirements of data protection or privacy for state action, or that is a general exclusion for the information requisitions or information requests which are made, as long as they fall within narrow theoretical constructs of saying, oh, state security of India, everything is fine. The more you run into data equivalence formats or data equivalence tests like Schrems 2 and find that you're just not a compatible jurisdiction for harmonization, you're too far apart from global reality to ever be aligned. And even no matter the political and economic will basing it, the two concepts are normatively just not alignable, right? So I feel that this is a corollary of the first. The more you drift from the norm, the more trouble you'll have trying to make things fit. Yes, you can bridge. Yes, the US has done that to some extent. But can we do so effectively without sort of tying ourselves up into knots? I doubt it.
Thank you very much. And I would like to hear from, we would all like to hear from Supratim, what his take is on what is there for the e-commerce to offer.
Thank you, ma'am. I'll take a cue from what Pawan Duggal said. And I completely agree that, we have huge potential. I think he touched upon the edtech sector as an example, which has got immense potential. We have seen in the recent times how Indian players have gone places, okay, and they are doing fantastic. Uh, uh, but the other aspect, which Arun also sort of touched upon, is important to keep in mind. Our government, for example, in several papers that they have taken out, have said that we want to now move from a lower rung of data processor, for example, to higher end, and therefore we are bringing in things like data localization. Now we have to be very careful when we are saying things like this. Whilst possibly the ultimate goal could be very noble, that's having more infrastructure, creating more jobs, so on and so forth. But the manner in which it is being done, we need to be very careful, because that could actually backfire. And the international players who have been looking up to India as a playground where they can do business with certain degree of flexibility, that could be counterproductive. Of course, there are regulations required, but we need to be very careful about how and what we are bringing in the name of things like, say, data localization, which has got several theories around this. I'm not getting into those, but yeah, I think there we need to have a balanced approach.
Thank you very much. And I would now request Professor Tashik to give us his take on what e-commerce, or what are the opportunities that are there as far as e-commerce is concerned for countries.
Well, of course, as far as India is concerned, and please pardon me because I'm not that familiar with the Indian context. Nonetheless, yes. I'm very well aware of the fact that it's an enormous market and quick development. And of course, from what I've read, also the e-commerce and e-transactions are on the rise in India, which of course provides an excellent opportunity to find new methods of regulation and new methods of adjudication, arbitration as well. Of course, there are certain examples that might be used in order to develop India's own practices in this field. But what I believe is the crucial asset of India is the intersection of, on the one hand, a very huge market, on the other hand, the great intellectual and legal potential of the country, which allows you to produce your own standards and your own methods of protection of data in e-commerce and arbitration. And I sincerely hope to get more familiar with the products that will be elaborated in India.
Thank you very much. And we've moved to, we had all our panelists telling us their views about the position of India as far as e-commerce is concerned. And we just go to the next question that was there, which Dr. Gurpur had put about the need for a global mediation tribunal. I'll take it from you, Professor Tajik, first, that what is your stand on the need for a global mediation tribunal, especially when we talk about the digitalization technology and the way technology has made so much of difference as far as trade and things are concerned?
It is usually said that law is conservative, that it reacts with a certain inertia to social reality. And if this is true for domestic law, it is all the more true for international law, which of course very often lags behind the changes that happen in social reality and in the material world. As an international lawyer, I'm very much for the construction of new methods of adjudication in this area. Of course, it's a huge challenge. As we know, the big players in the field of using personal data are often bigger than individual countries. When we think about such companies as Facebook, as Google, there are huge players that on the international market might easily outweigh smaller countries. So, of course, the need of international regulation is very acute. In some regions of the world, this has been done, but it cannot be done partially. Because if such companies are being regulated, for example, in the US or in the EU, of course, they might play between various countries in order to find those which would be more eager to accommodate their interests and needs. But of course, I'm very much aware of the fact that putting up any kind of international body like this is always a significant challenge, however we want to think it up. Of course, cultural differences, economic interests need to be taken into account, and of course, it's not an easy matter to set up such a tribunal. But I believe that it would be necessary to at least try to think about such a project.
Thank you very much, Professor Tajik. And you've spoken about the differences that are there. Can I request Advocate Pawan Duggal to put forth his comments on the need for a global mediation tribunal?
Ma'am, there is a massive need for such a global media tribunal, but unfortunately, I don't see that happening very quickly. The reason for this is we already are seeing a policy vacuum at the international level. The last more than 2.5 decades, we have not been able to be successful in getting an international cyber law in place. There's no international cyber security law in place. The Budapest Convention at best represents the only successful international working treaty on cybercrime. But in a scenario like this, where today even the two working groups of the United Nations, being the United Nations Open-Ended Working Group and the United Nations Group of Governmental Experts, still not unanimous as to how international law is applicable to cyberspace. I think while the idea of having this international online media tribunal is a great, attractive idea, in reality, I see a lot of potential roadblocks as states and state and non-state actors will be inclined for the perpetuation of their covert and overt activities not to have such an online media tribunal. Why? Because this tribunal could ultimately land up naming and shaming. And that's something that all stakeholders currently want to strictly avoid in this scenario. So excellent idea, but I see some massive challenges in its practical implementation. Thanks.
That's right. May I have Advocate Gauri Gokhale giving your inputs into this?
What Mr. Duggal said, because when I got this question also, from your college in terms of the thought process, I again, came across a lot of these challenges in my own mind as to what is the basis, fundamental basis on which we are trying to create this kind of a thought process, because is it the dispute between the two private parties? Is it the dispute between the private party and the state? Or, we need to start as to which parties will, sort of approach this tribunal, right? So I think there is a lot of work to be done at the principle and the policy level to then maybe, come to this as to what are the laws which are going to be litigated before this. There is a lot of thinking required. So I don't believe that we are at any stage of reaching that in maybe next decade or so. I mean, going by the speed, and you are seeing more and more fragmentation. Honestly, if we see even whether it is taxation, I think we did not discuss about taxation also, right? Because even if you see OECD level discussion around digital taxation, the countries are just not able to collaborate or agree on the principle. India has gone with the equalization levy, then US is sort of debating that and creating a report against that, etc. So there is a lot of things to be required to be done at the fundamental level before we discuss at the dispute resolution level.
Thank you very much. I would now have Mr. Supratim Chakrabarti giving his inputs into the point on whether there is a need for a global mediation tribunal and what are his takes on the challenges that are there in it. 1 minute that you have with you.
Oh, thank you very much. I will not even utilize 1 minute because I completely agree with my previous speakers. It's a fantastic thought process and maybe we need to do a lot of homework. But today, as of today, I think this is a distant reality. We have to really work really hard towards this. Thank you.
Thank you very much. And I think I have Mr. Arun Prabhu to give his input on this. And I think everybody, although they feel that there is a need, the question is how do we go about doing it? How do we go about having this global mediation tribunal? Sir, over to you.
Just one thought, and I'm not, this is more a hope than reality, but given that media owners and content owners are organized often on global lines, and you see same large platforms in multiple jurisdictions, you see classifications being used across multiple jurisdictions, there remains the sort of great white hope of having a contractual mechanism which is agreed inter se around things like contractual takedowns, run on the basis of terms of use. You find that already being the de facto standard when some platforms dominate a particular space. So perhaps there is a private solution to this, but on the government side of it, I fully agree with my previous speakers. I mean, it's great to have, but I think it's too far away. And even on the private side, yes, you can have an electronic contract to enforce it. You can have a distributed ledger which kind of turns off your NFT if you get an order against it or something like that. But these are things which where implementation will be difficult without a legal imprimatur. But my only hope is of having a private sort of self-regulatory mechanism of a global nature, which may short circuit some of the legal alignment that needs to take place for a national mechanism to take place.
Thank you very much. We also have a few questions that are there. I'll just take one or two, and then I'll also leave it to Mr. Syanthan Bhattacharya to take over the question answer round that is there. I think there are a few questions. Would you, Shayantan, like me to take these questions, or would you take the questions on the chat box?
Ma'am, I believe that we can take the questions on the chat box so that they are transparent, and then we can proceed with picking from them.
Okay, all right. I think it was a very, very interesting panel discussion that we had, where we had all our panelists speaking about the various challenges that are there as far as technology is concerned, use of technology is concerned, about harmonization, about standardizations that are there, which should happen, but the problems that are there in going about with the standardization. And I think it would be wonderful if we had more time and we could discuss more on the various aspects more at length. But since time is of essence here, I'll go to the few questions that are there on the chat box. We have a question over here where one of the participants writes that he wants to know what are the potential demerits of the trend of increasing digitalization of global trade.
Sorry, ma'am, could you just repeat that? At least I couldn't hear the question.
The question that is there is, this participant wants to know what are the potential demerits of the trend of increasing digitalization of global trade. Am I audible?
Yes, ma'am. Yes, you are.
So, Pavan sir, would you like to answer this question?
Well, I can just say that there's nothing known as complete black and white. There is so much of gray around. So if you're saying that everything about the electronic digital trade is hunky-dory, then it's not. There are negative aspects as well. The digital trade is exposing all of us to legal consequences. We're all getting exposed to increasing cybersecurity breaches on a day-to-day basis. Ransomware is now the biggest headache as far as companies is concerned. Every 11 seconds, one company anywhere in the world becomes a victim of ransomware. So as you increasingly go onto the digital bandwagon and digital trade, you have to be mindful that there are numerous potholes, numerous gray areas, challenges that are waiting for you. The first challenge is that of cybersecurity, how to ensure that your data is secure and is not unauthorizedly accessed. The second important issue is how to ensure that you, as part of the digital trade ecosystem, do not become victims of cybercrime. Third issue is that of internet jurisdiction, because internet has made geography history. And unfortunately, because digital trade has put the entire world into one particular platform, there are practical difficulties whenever there are going to be disputes across distinctive jurisdictions and boundaries. So there are negatives, there are gray zones, but we can't go to the Himalayas. We can't say, look, let's turn our back to the electronic format. We have to take it with all its positives and negatives. We have to try to maximize the exposure or the benefits from the positives, and yet ensure that the negatives or the gray areas are minimized to the best extent possible, and that we be constantly prepared. When we are in digital trade, we must specifically focus on inculcating not just cyber security as a way of life, but also for the purposes of ensuring that cyber resilience has to be adhered to, not as a lip service, but as a part of day-to-day activity of any digital corporate who's working in digital trade. Thanks.
Thank you very much, sir. May I now request Mr. Shayantan Bhattacharya to take up the next few questions that are there. Yeah.
Certainly, ma'am. Okay. The next question is, cryptocurrency is a major way of digitalizing and modernizing trade. Will the court ban it or regulate it in the near future? I believe this is in the abstract. So if the panel would like to answer that.
Well, I can just say that, look, there's nothing known as banning of a cryptocurrency. You cannot ban a cryptocurrency because there's no legality attached to it for it to be banned. Number two, you can't close your eyes to the sun and say, let me adopt an ostrich approach. So I think much that you may want to ban currencies, the fact is they are the digital present and they are the digital future. So rather than banning, it's much more better if sovereign governments are able to take the best advantage and benefit out of the cryptocurrency ecosystem rather than merely banning it. Thanks.
Thank you, sir. We have another question. I myself have a question as well. I'll ask that after this then. The next question is, how important are data privacy laws with respect to ensuring fair trade practices in the future? Again, this is open to the panel, if anybody would.
Yeah, so maybe I'll take a shot and then others can join. Of course, it's already becoming fairly important in international trade, and it'll continue to be more important. I think that's all that I would like to say on this.
So I think, let me just come in here. I think when we talk about data protection, right, in the traditional sense, we were talking only to protect, and what are we protecting against, right? Is it the leakage? It is the harm in the manner in which the data has been used. So I think, it's much larger space now when you talk about data and not, necessarily limited to one particular law. Right, the competition law, then there are consumer protection laws, there are multiple laws that are now governing this particular space, right? Even if you see under the Consumer Protection Act 2019, we have not spoken about it, but the e-commerce rules that came in under that act, right? That is, or even the definition of unfair trade practice somewhere also talks about the data, right? So it is multiple laws that will sort of look at the holistic fair trade practices, and not just from a protection perspective, right? I thought I'll just, because the way the question is asked, just for the the audience, just to clarify that element. So as a lawyer, you will need to look at multi-dimensionally than just the protection as a dimension. I hope that answers their question.
If any other member of the panel would also like to give their points in this regard, or we can move to the next question then. Fine. The next question, if I may ask one of my own, I was very interested in what Professor Tachik spoke about, especially when you highlighted the private law elements of this, as opposed to merely public policy considerations. My question would focus on a private law consideration outside of contract or tort. My question pertains to restitution, especially when individuals are not well acquainted with the internet infrastructure, and they end up transferring data which is very valuable as an asset to another party. There are two questions that I would like to ask in this regard. First, would the panel consider restitution to be applicable? Would you think that something as intangible as data can properly be covered and transferred back as a gain in this regard? And secondly, if we do concede to this, given the fact that data can be replicated, leaves residues, etc., and our present platforms are not optimized for this, would you have any suggestions as to how the retransfer of such data can take place? Thank you.
So when just to understand your question clearly, see, when we talk about data, right, we can't just say data, right? There is a certain data which I, as a user, have given you. Then there is a data that the platform has, seen from my profiling. And then there is a layered data that gets, done further on in terms of analytics, etc. Right? So when we talk about data and the question attached to data, we need to understand in what context that question has been asked. So which type of data are we really talking about? Could you just explain that so that I think all of us can react to that?
Absolutely, ma'am. So my question would pertain to where data related assets are there. For instance, institutional players have been a big concern over here. Big tech would have a lot of assets which would be data focused. And if there were the unintended transfer of such an asset to another party, would you think that that can be restituted back to that big tech organization or any other party? And secondly, since it is an intangible asset property in this regard, and it can leave residues. It can be replicated. It can also be clandestinely utilized by the party who gets hold of this data. How would you think that the internet infrastructure can be optimized to allow for such restitution in the future? So if that makes my question clear.
Well, if I may add something. Of course, the trouble with damages that might be done by the leak of personal or private data is very specific due to the fact which you have mentioned, namely the question of replication and the fact that once the data are leaked, we can no longer hold control over it, and they might spread, they might be used by any actor in the world. And of course, we know that there are some malicious actors that would like to get our data and use them. So the approach of lawmaking, especially in the EU context, has been to try to impose the most severe regulations on the use of data, and the very crucial principle of the GDPR, namely the minimalization of data. So data should be personal data should be used and processed only in cases when this is necessary. So that's one approach to reduce the possibility. Given that once something bad happens, we can hardly provide any form of restitution. Of course, we can think about litigation, compensation, stuff like that, but we effectively lose control over what's going to happen. So the best approach, perhaps, is to try to limit at the opening stage, at the opening moment, the use of private data.
Certainly. Thank you so much, sir, for that answer. We move to the last question then, subsequent to which we will be ending this session. Okay. The last question that we have is, with reference to anonymity online, we see that there are obvious benefits to the individual. However, when this goes a step beyond into the dark web or other, I'm assuming, related aspects wherein data might be used for untoward purposes, the anonymity might be a mask for illegal actions. And the question pertains to how can this be regulated appropriately in the interest of public policy? And if the panel may respond to that.
Let me begin by saying darknet is not just the deep underbelly of the internet. Darknet is now the new ground reality. As per the latest estimates, they say it's 500 times the size of the superficial net. So the time has come that you will have to start regulating the darknet, at least vis-a-vis those activities which are patently cybercriminal activities in the different jurisdictions. Darknet should not give you a license to engage in cybercrime. Yes, you want to go to the darknet for protecting your privacy, for expression of your thought processes, you're more than welcome. But somewhere down the line, a legal framework will have to be done. In my book on darknet law and the anonymity darknet law, I've tried to argue that the time has come where the governments of the world have to come together and start coming up with legal frameworks. But nobody knows how to actually enforce those legal frameworks. Technically, the IT Act would be applicable to the darknet, but how do you enforce the IT Act in the darknet? One good scenario is that Interpol has already begun to start coming up with new training on cybercrime on the darknet for law enforcement agencies. But still, because a number of states actors are doing both covert and overt activities, including activities on the darknet, they would currently not be in a mental frame of mind to go in the direction of a regulation of darknet. So while it's a good idea whose time has come, but because there's a hesitancy on the part of state and non-state actors to work in that direction, I don't see some major developments in this regard in the next few years. Thanks.
Advocate Duggal, just to add, I think fantastic points made. Just one point here, that on the domestic laws front, I think we are trying to do a bit, whatever is possible, given the restrictions. For example, Advocate Duggal also spoke about the 2011 IT rules, that is trying to go behind this aspects of anonymity and see whether they can be, these players can be sort of actually identified when it is really required by the law enforcement authorities. Number one. Number two, the Personal Data Protection Bill also calls out a very interesting aspect of, and it's also there in the other some other papers, to have an element of self-authentication in larger platforms. So what happens, say you will have a green tick against your name, so you are basically authenticated as a true user, wherein people can interact with you and know that you are the real user behind this profile. Things like those. A lot is happening around this, but again, uphill task, quite a bit to do.
Honestly, this is one area of anonymity, something I have not been able to sort of come to grips as to what is the right thing. Because if you're saying, I want to exercise my freedom of speech and expression, then who are you is something also you need to disclose, right? I mean, that is where I'm still not convinced that anonymity is a fundamental right to say that I can be anonymous and say what I want. I don't know whether what other panel thinks, whether they have made up their mind, but I have personally not made up my mind that that is a right that one can exercise because in a real world, can you just stand and say whatever and say that you don't know me, right? I mean, I always try to sort of draw a simile with the real world. So if in the real world, was the anonymity possible for you? If not, can that be sought as a right in the digital world? I mean, that is the area itself. I don't think that there is a clear answer to that yet, at least to my not to my knowledge.
Okay. With that, we come to an end of this session as well. I thank our guests for the wonderful and engaging session that we witnessed. And with that, I would request Professor Dr. Bindu Ronald ma'am to kindly deliver the vote of thanks.
Thank you, Shayantan. Global trade has definitely transformed over the period of time. And today, when we look at a globalized world, we find that it is driven by a combination of new technologies that are there and new policy rules, which are providing great power. And as we come to the end of this conclave, after such a wonderful discussion with all our panel members, it's my privilege to thank everyone who have contributed to the success of the conclave. We've surely transcended the physical boundaries, and we've had presence of international participants also in this conclave. I'd first of all like to thank Honorable Justice Reddy, currently the 8th Lokayukta of the state of Karnataka and former judge of the Karnataka High Court, who was our chief guest of the conclave, Justice Anil Kumar Menon, Judge Mumbai High Court, our guest of honor, and Dr. Annabel Bennett, Chancellor Bond University and former judge of the Federal Court of Australia, who was our distinguished guest, for agreeing to be part of this conclave and for enlightening the audience with their very, very rich discourse on the various aspects of trade and globalization, which is an inseparable part of growth and development. I'd also take this opportunity to extend our gratitude to all our esteemed members of the panel who, through their discussions, very rich discussions, contributed to the success of the International Legal Panel discussion in the Conclave 2021. And our special thanks to Senior Advocate Rotagi, Senior Advocate Tripathi, Advocate Pawan Dukal, Professor Tarchik, Advocate Gauri Gokhale, Advocate Arun Prabhu, and Advocate Supratim Chakrabarti for being part of the panel discussion. I also place on record our appreciation to the members of our top management, Professor S.B. Mujumdar, Sir Chancellor, Symbiosis International University, Dr. Vidya Yeravdekar, Pro-Chancellor, Symbiosis International University, and Professor Rajni Gupte, Vice Chancellor, Symbiosis International University, for their constant encouragement and support to Symbiosis Law School in organizing various events. In fact, we had Dr. Rajni Gupte and Dr. Vidya Yaravdekar as part of our inaugural session also today. I also take this opportunity to thank Professor Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, for her vision to get the best to the law school. She has definitely taken this law school to great heights, and I thank her for all her support in organizing events. And I also thank her for moderating this session so wonderfully. It is a great work that is there, which was put together by our student team, which is led by Mr. Sher Villadapur, who is the convener of SIMBA and President Student Council. Mr. Faranta for all the work that he has put together for getting our resource persons, along with other team members, all the students in the organizing team of SIMBA and Conclave. And I also thank the faculty team and IT team that has provided their support in organizing this event. I must place on record that we have had a huge participation to this event, which has seen a registration of over 1,500 participants. And I thank all the participants for their presence to the conclave. We do promise you a wonderful time in the 3 days of SIMBA that is going to be there for all. Be part of this wonderful festival which we have in the next few days. Thank you. Thank you one and all.
Thank you. Thank you.
Thank you.
Thank you.
Thank you.
Thank you, everyone.